for today, so we'll go ahead and move to special orders. The first bill we're going to hear under special order is House Bill 1726 by Representative Ray. Committee members, there is an amendment to this bill, so staff will be passing out that amendment at this time. Representative Ray, you're recognized to present your amendment.
Thank you, Mr. Chairman. Representative David Ray, District 69. Colleagues, the amendment just corrects a drafting error where one of the sections was misnumbered. I'd appreciate adopting the amendment.
Any questions from committee members? Seeing none, Representative Ray, you close with your amendment?
Yes, sir.
Do I have a motion? Have a motion of due pass on the amendment. All in favor, say aye. All opposed, say no. Congratulations, the amendment is passed. Now you can present your bill as amended.
Thank you, Mr. Chairman. Before I explain the bill, I'd like to let my guest here introduce himself.
Yes, please do.
Ryan Owsley, Deputy Attorney General in the Opinions Division at the AG's office.
Okay, Representative, thank you for being here, sir. You're recognized to present your bill.
Thank you. Representative Ray asked me to give a little bit of background on myself, to give the framework for the remarks that I'll have interspersed with Representative Ray's comments. I've been at the AG's office now for 12 total years. I provided 150 different trainings around the state to state officials at all levels of state, county, city, school governments. I've provided training on FOIA responses to government officials. I provided training to interested citizens on how to make FOIA requests, and I provided CLEs to attorneys around the state on the FOIA. I'm the primary editor of 3 editions of the FOIA handbook that the AG's office puts out in conjunction with the Press Association. I've litigated FOIA cases in Pulaski County Circuit Court and before the Arkansas Supreme Court, and I've written hundreds of FOIA opinions for now 3 attorneys general.
All right. Thank you for that, Ryan. So, colleagues, House Bill 1726 obviously deals with the Freedom of Information Act. And before I walk through the mechanics of the bill, I just want to state that this bill has broad support. It's supported by Governor Sarah Huckabee Sanders, Attorney General Tim Griffin, Secretary of State John Thurston. Law enforcement are united in their support of this bill, including the state police, the Sheriff's Association, and the chiefs of police, as well as a host of other organizations that I'm sure will testify here to share their support. You know, there's some things in our politics that it's sometimes difficult to have an honest conversation about. Social Security comes to mind, insolvent pension systems is another, and then there's FOIA. And in almost every discussion of FOIA, the debate is painted as a binary choice, that there's government on one side and citizens on the other, and you have to pick a side. You're either with one and against the other, or vice versa. That is a false dilemma. It is possible to have both a transparent government and one that isn't paralyzed by crippling inefficiencies. The way that I would encourage you to think about this issue is like this. Nobody wants government to be a black box. That's one extreme on this end of the continuum. On the other hand, government can't always be a fishbowl. That's the other end of the continuum. And between these 2 points on the continuum, between the black box and the fishbowl, there are literally 1,000 different points along that continuum where FOIA laws can and do fall routinely. Our FOIA isn't a single law that falls on a single point of that continuum. It's a series of things that sit at different parts of that continuum based on a variety of factors and considerations. Financial records, for example, how the taxpayer money is spent. That always has, always should, and always will sit very close to the fishbowl end of the continuum, because there's a close connection oftentimes between money and corruption. Other records like employment evaluations and such fall much closer to the black box end of the continuum. I think about the list of concealed carry permit holders that was disclosed, that was FOIA'd and disclosed by a journalist. And then this body, after witnessing that reckless action, decided to pass a law that put it close to the black box, that exempted it from FOIA. So as you hear people, as you hear the opponents testify against this bill and paint it as good versus evil or heaven versus hell, please keep that framework in mind and know all of the different points on that continuum, and that reasonable people can have disagreements about which particular point on the continuum each type of record should fall. I think everybody here supports transparency in government, and we're proud to have a strong FOIA law. At the same time, as lawmakers, we have to be responsive to issues that arise, to trends that develop, and make adjustments to laws as necessary over time. I can't think of almost no law that is so sacrosanct that it doesn't need to be revisited over time to make necessary adjustments and improvements. The fact is that many provisions of our FOIA laws have become liabilities. FOIA can be routinely abused, weaponized, and used as a retaliatory weapon of revenge, and the sheer volume of requests and the ultra-voluminous nature of many of those requests can easily grind agencies to a halt, which prevents them from performing some of the most basic functions in serving the public. I recently talked to one school district who told me that they recently received a FOIA request that totaled 800,000 documents. Not 800 documents, not 8,000 documents, 800,000 documents. They estimated that it would take their FOIA compliance officer nearly 2 years to comply with that request. But that's not how the law works. The law only gives you 3 days to comply, and there are no exceptions to that. So they would be violating the law for every single day beyond the 3 days that they do not provide those 800,000 documents. Last week I talked to one of our smaller state agencies where they told me about an employee that had to be let go a couple of years ago. And simply as a matter of revenge, almost every week since that employee was let go, they submit a dozen or more FOIA requests. Not small, minor requests, not requests designed to elicit important information, but large requests, voluminous requests, simply to paralyze and retaliate against their former coworkers. So you'll hear other examples like this from folks who have come to testify for the bill. You'll hear more examples of FOIA being weaponized in a way that doesn't just make life inconvenient for a handful of government bureaucrats, because to be honest, I could care less about that, but that does it in a way that deprives citizens of a government that is focused on providing even basic services like public safety and fire protection. The things I described do not serve the public interest. Blowing through millions of dollars of taxpayer money on an army of FOIA compliance officers that all have to be paid between $60,000 and $100,000 is not fiscally conservative. Many of these trends were impossible to foresee in 1967 when FOIA was originally adopted. So this bill does 7 things. The changes contained in it balance the value of transparency with the need for government to be able to function efficiently. And in the end, I believe that the public will be one of the primary beneficiaries of these changes. So I'm going to explain what each of the sections of the bill do, and I'm going to ask Mr. Owsley to intersperse some of his comments with mine. So this will be a little bit unconventional. The first thing the bill does in Section 2 is it exempts records related to ongoing law enforcement investigations. Currently, only undisclosed criminal investigations are exempted from FOIA. This would expand that exemption to include ongoing investigations. If videos of a pursuit are released as the law currently requires, an investigation may be ineffective or even compromised. Publishing of a video may also risk a fair trial for the defendant or the subject of the investigation. And being able to delay the release of these records just for a period of time ensures that both sides get a fair trial, a fair investigation, and if necessary, a trial. Currently, law enforcement agencies have to divvy up their resources between investigating crimes and answering FOIA requests about them. Defense attorneys are skipping the usual court discovery process and using our broad FOIA laws in court cases instead. There's been a lot of discussion the last couple of years about backing the blue on one side and defunding the police on the other. And I will tell you, our law enforcement do have to divert precious resources from things that would otherwise go to public safety simply to comply with people who are FOIAing mountains of documents and dash cam footage, in many cases, simply to make a quick buck on a blog. I should also note that this exemption doesn't just help law enforcement, although it does. It protects the innocent. Not every person who is investigated is guilty. That's important to remember. Not every investigation leads to charges. And making sure that information subject to FOIA, making that information subject to FOIA undoubtedly puts a cloud of suspicion on innocent people in some instances. And that, having that exemption, is in the best interest of the public. Do you have anything to add, Ryan?
Yeah, just very briefly, part of what I hope to add to the comments here is to give you a thumbnail sketch of how other states thread the needle here between government transparency and government efficiency. We're not the first ones to consider the question of where that balance ought to lie. So you'll hear a variety of people come, I'm sure, and tell you what your policy perspective ought to be on that. My hope is to tell you how other policymakers have threaded that needle as well, so you can be fully informed when you make your own decision on this. The majority of states have an exception that covers these kinds of ongoing, undisclosed criminal investigations. And I did some quick research for the states that are around us. For example, Texas has one, just like the language here. Oklahoma has one, Missouri has one, and the federal FOIA, which predates our FOIA by 1 year, also has one. So these kinds of exceptions are standard among other states, and you should be aware of that.
The second thing the bill does in Section 3, it adds an attorney-client privilege into FOIA. When a private citizen gets advice from an attorney, that advice is protected. But leaders in executive agencies can't do the same. And so the critical questions that they ask their attorneys can be public within 3 days. As you can imagine, this makes critical decision-making communications arduous at best and impossible at worst. Not having attorney-client privilege anywhere in our FOIA has the potential to force the state to reveal their litigation strategy to the person bringing suit against them. And that may or may not be in the best interest of the public. Lawsuits are adversarial by nature, just like sports. Imagine how the unfair advantage that would be created if one team's football coach could access the playbook of the other team's coach prior to the game. That's essentially what can happen in these instances. So this change would allow employees to get the best possible legal advice, which is, again, in the best interest of the public, and getting better and more candid legal advice would also help prevent accidental behavior that's illegal, which is also in the best interest of the public.
Nearly every state that has a FOIA exempts attorney-client communications, and the very next one, the work product doctrine. Again, Texas has an attorney-client privilege in their FOIA and a work product doctrine, which is this next one, which we'll look at here momentarily. Oklahoma has the same exemption. Missouri has the same exemption. Mississippi has the same exemption, and so does the federal FOIA. The idea here, to the point earlier about the false dichotomy between do you help government or do you help citizens, in a representative democracy, you yourself, as a citizen, insofar as you have your citizen hat on, you can go to your attorney and have this sort of sacrosanct privilege where you have an attorney-client relationship, and the stuff you say to your attorney is between you and your attorney. And then whenever your elected representatives go and now they represent you, the majority of other jurisdictions that have considered whether that elected representative ought to have the same kinds of privileges, the majority of those jurisdictions have said yes. In Arkansas, we don't have that. The text of the FOIA doesn't contain such a thing, and there was an Arkansas Supreme Court case in the early 2000s that said part of the reason why we shouldn't have such a thing is that government attorneys, the client of a government attorney is the people. That's patently false. The rules of professional conduct that are published by the Arkansas Supreme Court, and that were in effect at that time, say they have a very careful, detailed definition of who my client is as an attorney. And the reason that's very important is because that's the person to whom I owe all of these obligations of candor, of fidelity, and that's the person to whom I have this fiduciary obligation. And law students are trained on this kind of, and it's actually part of the bar exam. So a government's client is not the citizen. The government lawyer is serving the citizen. And the majority of people I've had the privilege to work with in the government are outstanding lawyers who love public service. And that's the reason why they're there instead of at a tall building firm where they could make perhaps a lot more money, but they really enjoy what they're doing and they enjoy the service. And so they don't see what they're doing as keeping things from the public. They see themselves as serving their client under the normal rules of client-lawyer relationship, which most jurisdictions agree with.
The next thing the bill does, also in Section 3, is it adds a deliberative process exemption or privilege. There's a number of states, including Texas, Ohio, Alaska, several others, and the federal government, that have an exception to FOIA for deliberative process. And deliberative process is the basis for many of the exceptions that already exist in FOIA. It's why the governor's office and the attorney general office have a working papers exemption. It's why personnel matters at a school board meeting can be discussed in executive privilege. It's why employee evaluations are, except under extreme circumstances, not disclosable. And frankly, it's why all of you as lawmakers have a legislative privilege. Imagine if every email that you sent to BLR asking them to research this topic or that topic were subject to FOIA. Imagine if every iteration of every bill you've ever drafted, not just the finished product that you file that's public, but every draft, the changes, the iterations that it goes through were public. That would severely hamper an already difficult policy-making process. No business could possibly function if its decision-making process were in a constant state of exposure. Now, state action should absolutely be public. Nobody disagrees with that. But the deliberative process leading to that action can't exist inside a fishbowl. And because there's a chilling effect on the deliberative process. There's a lack of candor. Ideas that maybe fall outside the Overton window aren't brought forward and put into the discussion. People don't speak up and offer their input. And so allowing for that deliberative process improves the decision-making. It improves outcomes. And who benefits from better outcomes and decision-making in the public policy process? It's the public that benefits from that. I would also point out that all of the deliberative process documents are still subject to subpoena. The actions of government are still public, and provide for citizen input. If the deliberative process, for example, results in a rule, there's still going to be notice and comment allowed. And the other side is going to tell you that this exemption will just lead to no documents, and that's just not true. the laboratory of democracy in our state, in other states, and the laboratory of history teaches us that even with the working papers exemption, there's a lot of documents that are still going to be available that are covered, that are not covered by the FOIA exemption.
So Arkansas already has a type of deliberative process exception that was added to the FOIA in the 1980s. That's the working papers exception, which each member of this committee enjoys, along with the other constitutional officers. Unpublished working papers, unpublished memoranda, and unpublished correspondence are exempt from disclosure under the FOIA. That's a type of deliberative process exception because the whole idea is that it's supposed to capture information that's pre-decisional between decision makers at a high level. So this is not a stranger to the FOIA is my point there. And you should know with respect to the background of the deliberative process exception itself, this is part of the federal FOIA, which I mentioned earlier, predates us by about a year. And it's got a well-developed case law in the federal courts. And my suspicion is that if this bill were to pass and to become law, then if in a court construing these provisions would pull from that well-developed body of case law in the federal courts to interpret this very language and say that there are two elements for this language in order for it to apply to a particular document. So it's not going to be that this document shields just any record at all. The elements that the federal courts have settled on is that the document must be pre-decisional in nature, so you can't, create a document after the policy's been made and then try to apply this provision. And also, it must be opinion-based. It must express someone's opinion. It can't be just data or facts. So there is a limitation in this well-developed body of case law in the federal courts that this language keys off of. And I say again that some other states have this as well, including Texas, Oklahoma, Missouri.
Okay, the next thing the bill does, I believe this is the last thing in Section 3, it exempts intellectual property and research created by universities and state agencies. Sometimes our universities generate proprietary information that has significant financial value, including in some instances patentable technology. This bill would exempt proprietary information from FOIA. I believe there's some universities that have come here today that can share some examples with you of that, but there's studies done on herbicides, seed variety, soil and water quality, things of that nature. And people can currently request preliminary unpublished research results through FOIA, and that creates several problems. It gives an advantage to competitors to know which direction that research is going. If you release partial results of research, public may draw incorrect conclusions from that. It would allow other researchers to scoop projects and preempt their research that might limit other opportunities for successful promotion of our institutions. And most importantly, it could compromise intellectual property rights for newly developed or developing technology. And do you have anything to add to that, Ryan? Okay. I'll move on to the fifth thing of 7. I promise we're getting there. Section 4 addresses the problem of uncompensated man hours in FOIA requests. This portion of the bill would ensure that modest FOIA requests, small FOIA requests are fulfilled free of charge to the requester, but for reimbursements, but it would allow for, it would not require, but it would allow for reimbursements that are particularly voluminous, those that take more than 8 hours to comply, so an employee's entire working day to compile, they would be able to charge for reimbursement of those man hours. The cost of that request would be for the hourly wage over 8 hours of the lowest paid employee qualified to fulfill that request. And this is particularly a problem, as I mentioned earlier, in law enforcement. State police, for example, have 3 full-time employees whose only job is just to review requested dash cam and body cam footage and make the necessary redactions. And so some of these requests particularly the very large, voluminous ones, are a severe drain on precious resources that could be being diverted, or that could be going as they were intended to go to public safety. I do want to stress, any sort of small or modest request is still going to be covered free of charge under 8 hours. Again, this is to the public benefit because taxpayers currently get stuck with the tab when these ultra-voluminous requests are filed. Now, the opponents of this bill are going to say, oh, well, this is why I pay taxes. I pay my taxes, so this should be handled for free. In fact, the example that I saw in the newspaper the other day was they equated this to if you call the police and they show up at your house, if they then handed you a bill to pay for that. Well, no, this is not like that. But even if it was, it would be an abuse on your part if you called your police department 3 times a day and asked them to respond to something at your house over and over just because you wanted to see them show up. That's what's happening a lot of the time. You would be draining that department of their resources. It's important to remember that no government agency exists primarily for the purpose of complying with FOIA requests. They all have a job to do. The police keep us safe, the highway department paves the roads, schools educate children. These sorts of things are special uses. And it is perfectly normal for government to charge a fee for a special use. So take, for example, circuit court. When you go to circuit court, the courtroom, the judges, the buildings, the personnel, that's all paid for with your tax dollars. But if you file a lawsuit in circuit court, you have to pay a filing fee. That is a special use. You go to a state park and you decide you want to stay for a week at the campground. There's a fee for that. That's considered a special use. This is a very normal thing in government.
29 states allow their records custodians to charge for personnel time, and the majority of those charge from the moment they start collecting the records. As we see here today, Arkansas does not allow any charge at all. So by allowing a charge, we move into the majority of the states, and by fixing that charge, the clock to begin at after 8 hours and a minute. It doesn't capture the prior 8 hours, but the clock would then start at that time, which is pretty lenient, even among the states who do charge for personnel time. 29 states.
Okay, the 6th of 7 thing that this bill does in Section 5, it addresses the problem of very difficult, if not impossible, FOIA turnaround times by adjusting the response time to 10 days. This change would put Arkansas in the relative middle of FOIA response times compared to other states. If a FOIA request could not be processed within 10 days, the state would be required to give notice of why and when those records will be produced. Why is this necessary? Because government workers routinely encounter situations where it is impossible to comply with the law, where situations where every employee working every available hour could not humanly possibly comply with the 3-day requirement. Consider the example I gave you earlier where 800,000 documents were requested. Or think about how long it would take the health department to compile if you requested every record that used the word COVID dating back to March of 2020. That would take a long time to compile. The problem is that the law doesn't allow for any exception, none whatsoever. And so for someone like me who believes in the rule of law, it seems like it's a bad idea for us to have laws that are literally impossible to abide by. And you have to remember, for the people compiling FOIA requests, they have to walk a tightrope because not only do they have to deliver that requested product within 3 days to the requester, they also can't disclose any information that is exempted. And tripping up on either of those would create a violation. And so all of those documents have to be reviewed to see if information needs to be redacted for some other reason in the law. Again, this change will have a public benefit. Currently, taxpayers have to pay for many attorneys whose only job is to comply with FOIA requests. And this chews up millions of taxpayer dollars simply by extending the runway for response times. Agencies could accomplish the same goal using fewer resources and personnel and save taxpayers money.
Probably about 40 times over the last 15 years, and these different trainings that I alluded to earlier, I've had somebody, a government official at some level, raise their hand and ask me about situations that Representative Ray just described. What about a situation, they'll say, I have a situation right now where we have a FOIA request, and if I were to take every staff member off of what they're supposed to be doing and put them on responding to this FOIA, and we did that for 3 business days, we still would not be able to meet the time frame. What are we supposed to do? And my answer has always been the same. The answer is, you are forced to break the law. There is no exception in the FOIA right now, even if it is impossible physically to comply with the request. So what I've said to people is, you have to respond to the person in writing and explain the situation, and if they're upset about it, then they can sue you. And then you can hope that the court has mercy on you. But the reality there is, if the judge did say, well, we're going to give you a production schedule and we're going to extend the time frame for you to respond, that itself would be lawless, because there is no provision in the FOIA that allows the judge to do that, to set a reasonable time frame for disclosure. So what I want, I suspect this part of the bill there will be a lot of opposition to this, and I want to be clear about the language of what this actually does, and then I want to give you the landscape here about how this would fit Arkansas with the others. This is on page 5 of the bill, line 14. It doesn't say you wait 10 days to disclose. Right now, the rule is 3 business days. The rule is you must set a date and hour within 3 working days, at which time the record will be made available. Within. And there are Attorney General opinions that answer the question posed by the custodian, can I just wait always 3 days before I disclose? And the answer consistently in those AG opinions is no. You can't just wait once you have the document ready to go. You need to disclose that, because the text doesn't say you must wait until the 3rd day. It says that's your final deadline. That language remains unchanged in the bill. The thing that's been changed here is the number of days, from 3 days to 10 days, which would put us in about the middle of the pack among all the states in their response deadline. Again, I say, Texas, it's identical language to what this bill has. Oklahoma has no specific response deadline at all. It just tells the custodian that they must promptly respond. Missouri, 3 business days to give the records, or, this is very important, or respond in writing about why they cannot give the records within that amount of time and give the date certain by which they can. So there is a provision in the text of the FOIA that ensures that records custodians are not breaking the law without anything they can do about it. And that's what the next provision does on page 5, lines 17 through 21. It essentially codifies the Attorney General's advice over the years about sending that letter to the requester and explaining why they can't respond in the appropriate amount of time. And I add, this would give a textual basis for a judge who would be later reviewing whether someone delayed intentionally or failed to respond properly, where the judge could have a textual hook to allow them to respond in a more timely production schedule. And this, as I said, puts us in the middle of the pack, both with the states around us and the states as a whole.
All right, the last thing the bill does is in Section 6, it exempts cybercrime discussions from public meetings. I'm sure everyone saw the incident last year where the Little Rock School District was the victim of a Russian ransomware attack. This is not something that existed in 1967. The school district ended up agreeing to pay the attacker a ransom of $250,000, $250,000. This just puts those conversations in the same category of discussions as it would be like disciplining an employee, where you can discuss that in executive session. It's a very real concern that cyber criminals can use our open records laws to their advantage and then use that information to increase ransom payments. And that's what the bill does. Before we take questions, I do want to address one thing that I suspect will be brought up in the opposition, and that is my decision or not decision to attend the FOIA task force meeting to explain this bill. I was invited and I accepted an invitation to participate, but the meeting, which I did not schedule, was scheduled at a time when I had to run a bill in a Senate committee. I did not schedule that Senate committee meeting. It was a bill I had agreed to run, and I had multiple individuals who came into town from hours and hours away who drove here, as well as people on the other side who flew in from Washington, D.C. to testify against my bill. And I did not think it was fair to them or to my people to bail on that to attend this meeting. I informed the chair of the FOIA task force that I was unable to make it, and I explained why. For reasons unknown to me, he failed to communicate that during the FOIA task force meeting. And so I just wanted to clear that up, and we'll be happy to take any questions.
Any questions from committee members? Representative Womack, you're recognized for a question.
Thank you, Mr. Chair. If I'm misunderstanding this, feel free to clear me up. But why were school boards and cities and quorum courts and everything else on the list exempted from the attorney-client privilege? I mean, why were they not included in that, in this bill?
That was a decision that I made in consultation with my Senate sponsor, Senator Davis. You know, local government, in my opinion, local governments often have even less scrutiny than the state government does. You know, state government has a lot of media eyes and citizen eyes watching what goes on a day-to-day basis, and local government doesn't have quite as much scrutiny, and so that was my rationale for making that distinction.
Okay, thank you.
Representative Moore, you're recognized for a question.
Thank you, Mr. Chair. Representative Ray, my question has to do with the Part 5 of your bill, the uncompensated man hours. Who is the arbiter of determining what takes 8 hours to collect that information?
The answer to that is the same for all exemptions, and that's the records custodian. The records custodian makes the initial determinations here. They're the person on the front line. They're the one on the ground floor. And then that determination is reviewable by a court.
Any further questions from committee members? Representative Womack, you're recognized.
One more and I think I'm done. Those requests of extreme volume that you talked about earlier, I completely understand the situation. I was just curious, has anybody ever been prosecuted in the state of Arkansas for not being able to meet that deadline?
To my knowledge, I see someone holding up one finger. I don't know whether that's true. To my knowledge, I don't know whether someone's been prosecuted for not meeting the deadline. But there's two types of enforcement mechanisms in the FOIA. One is the prosecution, which could be a misdemeanor. The other one is, the majority of those I've seen are meetings related, not records related. The other type of enforcement is a civil action, which is the usual way that the records provisions are enforced. I'm not aware of any civil action where someone's been held liable where you can't physically meet it. But that goes to my point earlier, where most of the time the judges see this and they say, this is unreasonable because you can't physically comply. And isn't that weird that we have a law that sets some people up who in all good faith, and they can do everything they can and they still can't comply with the law. And so the judge has mercy on them, which they should, but there's no provision in the law that allows the judge to do that. Unlike the other states I referenced, the states around us specifically, that have a clause where you, as the custodian, can send the notice to the requester and say, we can't meet it, here's the reason why, and here's the date certain we can get it to you. And if the requester gets that and they feel like that's in bad faith, they can sue. And a judge can look behind that and say, well, what are the facts that supported the claim that you couldn't meet this? And what are the facts that supported that the earliest you could meet it was this date? And they can look behind that, and they could be held liable if they just make that kind of thing up, just like they could today.
Okay, thank you.
Any further questions from committee members? Seeing none, we have several people signed up to speak for and against the bill. Committee, we have 28 people signed up to speak against the bill for your information and 12 to speak for the bill. So just making you aware of that. So first person signed up to speak against the bill is Jimmy Gavin. Mr. Gavin. If you would, sir, just have a seat there at the end of the table and identify yourself. Identify yourself to the committee, and you're recognized to give your testimony.
Yes, sir. Thank you, Jimmy Cabin, citizen. The bills before you today are not of the people for the people. The bill is of the government for the government. I find it shocking that a Republican conservative governor and a Republican conservative attorney general would put the government ahead of the people. Even though I've read it to you before, I'm going to read it again. 2519-102, the intent of the Arkansas Freedom of Information Act, the very reason the act was created. It is vital in a democratic society that public business be performed in an open public manner so that the electors, that's me, that's them, shall be advised of the performance of public officials and of the decisions that are reached in public activity in making public policy. Toward this end, this chapter is adopted, making it possible for them or their representatives to learn and to fully report the activities of those officials. Each of you got to decide today, are you going to preserve and protect this act and this intent, or are you going to tear it up? My question is, who do you serve? Who do you serve, citizens or government? I want to take just a minute to tell you just a few things that the Arkansas Freedom of Information Act in its current form has provided to help citizens with. There was a 13-year-old little girl at a middle school who was threatened with a vicious graphic rape and then torturous murder. FOIA proved that the principal in that situation failed to notify the police and the Arkansas State Police Hotline. Separate deal. A teacher was left at a school, and a teacher left the school and went to go to other employment only to be turned down at two different places. FOIA proved that her former supervisor was releasing potential employers' personnel records that are exempt and was telling untruths about the teacher. FOIA provided video proof of a sheriff punching and choking a jail inmate just because he could. Central Arkansas Police Department chief mandated that each patrol officer make 4 traffic stops a day, and if they didn't, those officers would face punishment. Without FOIA, we would have never been able to prove it and put a stop to it. An inmate at a county jail died a horrific death of peritonitis as a result of being denied medical help and violating jail standards. Without FOIA, we would have never known about it or been able to prove that it happened. An autistic child was not only struck by an instructor at a school, but his individual education plan was not followed by federal and state guidelines. If it wasn't for FOIA, that young man would not be getting the proper care he needed, and we would have never known about the abuse. In November last year, a man died in a jail cell after being booked in on a misdemeanor. Without FOIA, we would have never known that the jail standards requiring hourly checks on him were never made, and that the deputy charged with monitoring the cameras for his cell was asleep the entire night. Through FOIA payroll records we were able to obtain and show what the school superintendents from the 10 largest school districts actually made versus what the school website says. Little Rock School District, the website said $270,000. It was actually $332. Payroll records. Fayetteville, $237,720 was actually $287,664. Cabot, $244,007. It was actually $286,257. Bentonville, $245,000. It was actually $270,408.26. Springdale, $240,000. It was actually $265,100. Fort Smith, $215,292. It was actually $260,455.12. Conway, $220,000 when it was actually $242,833.36. Let me add, in Fort Smith, did you know the state taxpayers are paying the superintendent's student loan? You know how we know that? For you. Last but not least, Little Rock Mayor Frank Scott. Without FOIA, we wouldn't know about the Lit Fest and Think Rubik's contracts, his lavish city credit card spending like the one that was over $1,200 at Arthur's Steakhouse for him and his friend, hundreds of thousands of dollars a year for the cost of his security detail. I'll bet last night Frank was sitting back reading this bill with a huge smile on his face while he was enjoying drinks that citizens paid for. I can't tell you right now, and I can't go into detail, but we have FBI investigations going on and other agency investigations going on that if it weren't for citizens' use of FOIA, wouldn't be happening. Now, none of what I just read you would have been able to be exposed, and none of those people would have got help if this law had been passed because, one, they would have been exempt, or two, I couldn't afford to get them. That would be holding my information at ransom. So I'm going to close with this. I'm going to ask you again. Who do you serve? Do you serve government or do you serve the people? Thank you, and I would very much welcome any questions.
Any questions from committee members? Representative Crawford, you're recognized for a question.
Thank you, Mr. Chair. And I'm for FOIA, just so you know. But we've heard, and I want to know, everybody in here who's going to speak against it, don't you think it's ridiculous of the 800,000 documents? That kind of stuff is what is ridiculous. The stuff you talked about in learning what's going on in the police and the jails, yes. But this kind of stuff where bloggers come and there's no restraint of what has to be done. And I'm just wondering, is there a compromise in that with the attorney-client privilege, with the unpublished research, with the response time, and with the cyber crime? So when we're dealing with people's lives and the police and city board of directors of the things we want to know is what's been said, the way the sausage is made, totally, I'm there. I am there. But when it comes to this other stuff that we heard, I just want to know if everyone who is against it believes there's a compromise we can make to where it doesn't wear on the government and the people, but that we can work together. That's my question.
No, I think it's a very good question, too. And I'll go back to this. I do understand there's abuse, okay? I've seen it, and it infuriates me. It really does. But we also go back to, let's liken it to gun control. We just had a mass shooting again, right? So is the answer to take away everybody's guns? Is the answer to take away so-called assault rifles that nobody can define? Is the answer to take away the rights from the citizens that are doing it correctly? So yes, ma'am, I agree. What I will say is this. This bill was, I feel like, intentionally filed at the end of this session to cram it through. If you guys want to do an interim study, then I think that's prudent, and I think we can try to find compromise. But to cram this through at the end and just take away my rights, the citizens' rights, what about the kid with autism? What about the family of the man that died in jail? We wouldn't even know about that, and we're going to take that away from those people just because we got some idiot in Little Rock that's filing bogus deals.
Okay, you didn't state the question, so
Mr.
I'm not
Gavin.
asking anymore.
Yes.
But thank you.
Mr. Gavin.
Yes, sir.
You speak on, I know you're speaking against the bill, but try to focus and stay on the bill itself. And not be referring to individuals or other people in
Sure.
some kind of derogatory way. So
Sure.
I would appreciate it if you.
Oh,
would
yes,
do
sir.
that.
Yes, sir. And if I did that, I apologize.
Well, I thought you called somebody an idiot, so, we can't.
I didn't name him, but yes, sir, I understand, and I apologize for
All
that.
right, well, I appreciate the apology. Representative Crawford, you have follow-up? Okay. Mr. Gavin, I see no further questions for you. Thank you for being here today. And signed
Thank
up
you.
next to speak,
Thank you, sir.
you're welcome. Signed up next to speak against the bill is Missy Bosch.
Missy had to leave, sir.
Do what, Missy?
to go home.
She had to go home?
Yes, sir.
Signed up to speak against the bill is Donnie Scroggins. Scroggins, you.
Thank you, Mr. Chairman. I'm Donnie Scroggins of the great county of Poinsett. I think you know where that's at. I'm in opposition to this bill, and I've heard the word abuse before I came here, that the government officials are being abused. Now, the two gentlemen that were here talked about this at the state level, but I'm a customer of FOIA mainly at the county level, which means all 75 counties. And I will tell you, Arkansas has one of the most robust, not only the most robust FOIA law in America today. I'm an expert witness in South Carolina, and you need to go there and see what their FOIA laws look like. I don't want to be middle of the pack, as they said. I want to be the premier state with FOIA. Now, that being said, we mentioned compromising. Let me tell you my experience with FOIA. Last summer, I started pulling what we call cast vote records, big item. I do all 75 counties. Let me tell you how I compromise. I do an email, a simple email, and I ask for these records, which are electronic records. It takes 3 to 5 minutes to pull off the laptop. Sometimes when I send the email on a Monday, I'll give them 5 business days. Sometimes I go 2 weeks without a response, and I actually have on my emails, please acknowledge this email. I've got clerks and or custodians. That's how I address them. Okay, so they know who's got to give me the records. I'll wait sometimes 2 weeks before a response. I do compromise. A 3-minute to 5-minute report will take me a month to get sometimes. I have counties now denying me CVRs and ballot review files just simply because they can. They refer me to the county attorneys. And then what's my remedy, to go sue? I don't have all the money to go sue in 75 counties. And there's no reason for that. So I do compromise. So I kind of feel abused by the system myself as a customer for you. And that being said, the 3 days things, hey, I get abused from government on that all the time. Most of my emails are not answered in 3 days. Here's my understanding. I send an email out on Monday morning asking for an electronic record, which they know exists. Sometimes they'll deny it, and I have to prove to them it exists. Actually, with the CVR files, I actually have to drive to the counties to show them how to pull off the electionware software computers these reports myself. I can't really use the computers. I'm just a computer guy. I've actually had to hire people to do Zoom meetings with clerks to show them how to pull CVR files. It's a 3 to 5 minute process. Now, the case where you're talking about 600,000 records, whatever, that is abuse. But I'll tell you, when I have clerks that won't deliver an electronic record to me in 3 to 5 minutes in the second business day, I'll negotiate with them. I do. That goes on. That's what goes on out there. You got the law, like they discussed the law, but what goes on out there is different, because I get abused, and I have to suffer going to court and paying for it myself on something that's simple. And also on page 2, it talks about likely. Who determines what likely to be used by law enforcement? Now, I understand ongoing investigations, all that stuff. I'm all for that. But I think FOIA handles that now. I know I can't go get an ongoing case file from the Truman Police Department. I know that. Or the state police. I don't expect it. I don't expect things that are in process. I understand that. We understand that as citizens. Also, the FOIA task force. I got the FOIA manual. I hope everybody has it. Why wasn't the task force here today? I mean, they're appointed. They have different people. Where's their opinion at on this? And as far as getting charged, I get my records electronically. I send an email, and the CVR files can be emailed to me in Excel spreadsheet. I've had them play around with me and give it to in some kind of crazy XML format. These clerks play around with you. They don't tell you the truth. I'll get an email to send the request to. a week later they'll say, well, that's the wrong email. So that's the kind of abuse that I get as a citizen. And also, we're talking about, I'm going to end this with the cybersecurity part. I'm a computer guy. I've been in computers since '79 when mainframes around. And I do a lot of cybersecurity work. And I will tell you that it's kind of light on that sentence or two at the last of this bill. It talks about cybersecurity. Let me tell you, if you're a public entity and you have, shall we say, a ransomware attack, like a school, this body, the first person that's going to be notified by law is state CISA. You have a state CISA agency, which falls under the federal CISA people. They're going to come in and actually install software in your system to try to mitigate what's going on. That had to happen at Little Rock. If not, they probably broke the law. Congressman Crawford gives great sessions on what CISA is and all this good stuff. So the cybersecurity thing, that's taken care of by CISA. What was it, 2 or 3 months ago when, I don't want to accuse, but I think a company called Fiddler out of Russellville, who ran most of the state's collectors and assessors software, they got hacked and it made the papers for 2 or 3 days, and that story has died. Can you FOIA to find out what happened? The only thing I can do is ask my assessor, are y'all back online off having these shoe boxes again? FOIA allows you to do that, but that's strange that story's disappeared. But also, as far as this determining 8 hours, I've actually was forced to go into a clerk's office to get an electronic record she could email to me. I took my own thumb drive, but she made me purchase her own thumb drive just to show that she could do it. That's the kind of abuse that citizens get. I'm talking to you from the other side of the table, and I've been doing this for 3 years full time now. And this bill, the first part of the bill, I mean, I understand the investigation stuff, but that to me is already covered. I'm not a lawyer. I can't follow all the logic that they had, but I am a citizen with an education. And to me, FOIA works for Arkansas. I don't know why we got these 2 bills up here late in the session, and we got a bunch of great FOIA bills that maybe or maybe didn't get heard today down the hallway. But I don't understand why these bills, it's just, to me, they're FOIA killers. And it's going to kill FOIA. It's going to gut it in Arkansas. And then maybe we'll have experts from other states come here and try to help us in court. But with that, I yield my time.
Any questions for Mr. Scroggins? Representative Richmond, you're recognized for a question.
Thank you, Mr. Chair. Yes, sir. I apologize. I missed. Would you restate your job, what it is that you do that requires you to have to reach out to these 75 counties and do this FOIA request with them?
Yeah, let me give you my journey. May of 2020, I checked my voter registration. I thought it was 0 there, so I thought I was a 0. And so I called the Secretary of State's office. He said, no, that means optional. So I know in January of 1980, I registered as a Republican, but in April of 06, all the databases got changed to optional. At one point, probably in 06, when they populated the database, the SOS, everybody was optional. Most people here who think you're a Republican right now, you need to go check your voter registration. Most Republicans are old for optional. Actually, optional is majority party in Arkansas. Maybe that's why we ain't closing our primaries. But I started that journey in May of 2020, and then I was a poll worker in November 20, and I had 125 ballots in our precinct there in Poinsett County. 2 people came in, and they said, well, our system, the poll book said, you've been voted for already. And they said, we hadn't voted yet. Okay, that's intriguing to me as a computer person, right? So we go ahead and we close out, and I go home at 12 o'clock, Trump's winning. And when I come in at 5, wake up at 5:30, he's losing. So, okay, I'm a computer guy, so let me start checking into this. So I started pulling these CVRs, which is part of the ESNES systems software. It comes off the electionware laptop that each county has one, and it's proprietary to ESNES. Now, proprietary is another word. A lot of the stuff with our election system I can't see because it's proprietary. And to me, I asked for a copy of just the database layout, and I was told by the SOS you can't have it, it's proprietary, because it might allow you to hack into their system, which is not correct. My background is computer science. I have a master's in political science, master's in public administration, and I have parts of 2 other master's degrees, thank goodness. But so that's where my journey began. So I am at a point, I'm in a special time for me because I'm retired. I can monetarily do election integrity work full time. That's what I do. I go counties to counties, committees to committees and talk. And so the hardware software end of our election system is my forte in Arkansas. And so that's my journey, 3 years.
Any further questions from committee members? Seeing none. Representative, Mr. Scroggins, thank you for your testimony here today.
Oh, thank you, Chairman.
Signed up to speak against the bill. Representative Berry, you have a question?
Motion.
Let me hear your motion.
Thank you, Mr. Chairman. In order to, we're able to hear all the testimony, I'd like to make a motion that we limit debate to 5 minutes per side.
We have a motion to limit debate to 5 minutes to each individual testifying at the end of the table. Is that correct? I understand your motion, 5 minutes for each one. Representative Womack?
So that's the limit testimony, not debate.
Yeah, that's the limit to the testimony, not the debate. Yeah, just for those that are signed up, speak for or against the bill, you want to limit it 5 minutes per individual, whether they're for or against the bill, 5 for each one. Is that correct? Okay, that is non-debatable. All in favor say aye. Aye. All opposed say no. The ayes have it. So for those of you that are signed up, speak for or against the bill, the clerk will time you when you sit down at the end of the table, and will notify you when the 5 minutes is up. And so next signed up to speak against the bill is Roger Kidd. Roger? I'll just have a seat there at the end of the table, and there's we just adopted a motion. I'm sure you heard that you'll have 5 minutes.
Thank you, sir. My name is Roger Kidd. I'm from Craighead County, Arkansas. I live outside the city limits of Jonesboro. I've been in this room since about 11:30 this morning, waiting to see y'all. I've been here in this building since about 8:30, 8:45 this morning. But I've changed my notes about this, about what I wanted to say several times since I've been here. I've been listening and I'm just sick. It just makes me sick. But I want to say, I'm going to start off and I'm going to read through, Mr. Chair, as fast as I can and get up and go. I'm not going to make any apologies about my passion, or I wouldn't be down here. I don't come down here often. And I'm going to state, after I read what I've got written down here, I'm going to state an experience that I'm going through in the now about FOIA. My first, FOIA was passed. FOIAs aren't here to make government officials or government jobs easier. That's not why it was written. It was written so the people could see what the government does. And I'm a Republican, and my mind is going to individual responsibility and initiative. And if it wasn't for us that are involved and here today, nobody would have probably even come up with a FOIA back in '67. Okay, so here I go. My first point, and I have 4. I see as a citizen, I'm going to look at this as like I need a defense attorney. I'm in trouble or something. The biggest problem with this bill is, quote, and any evidence or materials likely to be used by law enforcement in a criminal prosecution. Often, criminal defense attorneys use FOIA to determine how much they'll charge their clients, or to get discovery rather quickly in cases because the prosecution does not provide until after the arraignment. What that means to me as a citizen, if I've screwed up, I'm going to sit in jail longer. That's exactly what that means. Number 2, the Arkansas Constitution and our federal Constitution has a compulsory clause in the 5th Amendment. it gives the accused and the victim both the rights to see witnesses in favor, for, and against. The compulsory clause of the Fifth Amendment of the Arkansas Constitution and the federal Constitution is null and void on this bill. If a defense attorney does not have any evidence on me, he has to get a continuation of what I'm involved with, and I'm in jail longer again. Number 3, the section stating that FOIA requestors have to pay for printed records if the software of the custodian requires it. It incentives, it gives county clerks, government officials, it gives them incentives to have printing software that requires printing documents merely to avoid my FOIA request. Number 4, changing from 3 to 10 days. It's the government's job to respond to me. It's as simple as that. No, I'm gonna make one more statement and I'm done, Mr. Chair. I currently have 4 FOIAs going on right now at this moment. And out of 3 of those 4 FOIAs, 3 of those 4 FOIAs have been violated in non-compliance. On maybe one of them has 2 things, maybe another one has 1 thing, yada, yada. I'm a citizen and I cannot afford an attorney to take civil action. If anything at all about this bill and our FOIA laws, we need something for this little guy like me, the citizens, to be able to hire some type of civil representation, because I can't do it. Thank y'all for your time. God bless. I appreciate this. I hope I don't have to come back.
Mr. Kidd, that was amazing. That was 5 minutes on the money. So, any questions? Well, he's already left in the table. So, see you later. Signed up next to speak against the bill is Lori Justice. Ms. Justice, if you would, just have a seat at the end of the table, identify yourself to the committee, and reminder you have 5 minutes, and I'll let you know when the 5 minutes is up.
Yes, sir.
Thank you, ma'am.
Shouldn't be 5 minutes. My name is Lori Justice, and I represent myself. We heard at the beginning of this discussion from Representative Ray, and understand, with all due respect, I do like Representative Ray, but the fact of the matter is that our representatives work for us, the people. Okay? They don't work for the governor or the attorney general. They were hired and voted by us, the people, to represent us. And I just want to read you something. I'm going to be brief. I think most of us in here are Republicans. I want to read to you from our platform and our principles. We firmly support transparency and openness at every level of government. Those elected, appointed, and employed in government work for the taxpayers of this state and must provide information, public information, when requested in line with Arkansas's Freedom of Information Act. We support requiring that notice of public meetings be given not only to the press, but also directly to the people by posting notices on government websites and social media accounts and sending them by email to interested parties. Finally, we support continuing efforts to make clear to local governments that officials are not to conduct public meetings, public business, outside the parameters of duly noticed public meetings, so that the public has the opportunity to see the entire decision-making process and to participate if they so choose. And so I'm going to end with that, and I'm going to ask what your constituents want, because that's who everyone works for. So I would appreciate a no vote on this. Thank you.
Thank you for your testimony. Any questions from committee members? Seeing none, ma'am, thank you for being here. Signed up next to speak against the bill is Scott Gray. Mr. Gray, if you would, sir, just have a seat at the end of the table and identify yourself to the committee, and you're recognized. Have 5 minutes to give your testimony.
Thank you. I'm Scott Gray on behalf of the Saline County Republican Committee. I appreciate the time to speak today. By making FOIA requests more difficult and expensive, this bill creates doubt, suspicion, and ultimately leaves most taxpayers in the dark. I'll make 4 brief points. 1, taxpayers already fund these clerical positions. The administrative support staff gathering FOIA documents might think they work for the county clerk, the county judge, and mine just left the room, or the school district, but they ultimately work for the taxpayers who fund these positions. From our observation, we are already funding so many clerical positions that they often find themselves without much work to do. Go down to your local courthouse and you'll see that. It really isn't a burden on the local government to produce documents that already belong to the taxpayers. 2, as to the 8-hour proposal, FOIA requests are often the culmination of extensive research, and in many cases, though one individual is making the request, they're made on behalf of a much larger number of concerned citizens. I would argue that it's easier for a government office to fulfill one FOIA request that might take 10 hours than to receive and fulfill 10 separate requests. When we make these large requests, and I'm not talking about hundreds or thousands of hours, we're actually saving governmental employees time by not piecemealing. Further, the bill relies on the governmental agency to truthfully document the time and charges with zero oversight. That's an invitation for some corrupt custodian to overbill in an attempt to defeat the spirit of the FOIA law. Third, 10 days to respond to a records request is neither efficient nor transparent. A lot can happen in 10 days. Some custodians already stretch the 3 days out to 7 or 10. We've had multiple cases where counties would take a week to provide simple phone numbers, which should have already been on their website and shouldn't have required a FOIA request. If the law gives them 10 days, they might now take 30. Finally, these repeated attempts by Republicans to dismantle FOIA will only create more doubt, more suspicion, and more darkness. Our party platform says we believe in a transparent government, and that's the same party platform of Representative Ray and Senator Davis, who sponsored the bill. As ordinary citizens, FOIA laws are the one method we have to keep tabs on our government. Please don't thumb your noses at your own citizens. Work with the taxpayers rather than find ways to avoid them. Thank you.
Thank you, sir. Any questions from committee members? Seeing none, we appreciate you being here. Signed up next to speak against the bill is Allison Gray. Ms. Gray, if you would, just have a seat at the end of the table, identify yourself to the committee, and you're recognized to speak. Remind you have 5 minutes, ma'am.
Yes, sir. I'm Allison Gray, a registered Republican voter in Saline County and a member of the Saline County Republican Committee and Saline County Republican Women. In an email yesterday, Lindsay Bailey French, on behalf of the Arkansas Association of Counties, said the FOIA law, quote, has been twisted and abused as a political tool to punish the elected officials. She went on to say, quote, this abuse is now an all-time high. It's sad that our elected officials see us voters and taxpayers as the enemy. The more I've paid attention to politics, I've discovered that there is an us versus them mentality among the electeds, especially on the county level. Unfortunately, many of our electeds think they work for the Association of Arkansas Counties, as they are in this room today, and many of them are. Because of the emails they received from Ms. French yesterday is why they are here. If you pass this bill, you're letting a taxpayer-funded lobbyist group destroy our right to know what's happening in our own government. Arkansas is known for its strong taxpayer-friendly FOIA laws. This bill begins to chip away at those rights that the citizens who came before me worked so hard to obtain. That's why I strongly oppose this bill and urge you to put the taxpayers and Arkansas voters first.
Thank you, ma'am. Any questions from committee members? Seeing none, we appreciate you being here. Signed up to speak against the bill is Mike Matus. Matrix?
I'm going to pass on this bill.
Okay, Mr. Passing, all right. Next on the agenda to speak against the bill is Carl Watson. Mr. Watson, if you would, sir, just have a seat at the end of the table and identify yourself to the committee, and reminder you have 5 minutes and you're recognized to give your testimony.
Yes, I'm Carl Watson. I'm from the Flowers County of Jefferson. It's a dual stem flower. I guess I more or less have a question more than I do a statement. And I'd like to begin, I don't know if Representative Ray is still in the room or not, but my question really begins at page 1, line 32, ends at page 2, line 10. All of the additional language that's underlined there seems to address only state agencies and state employees. Doesn't say anything at all about municipalities, counties, school boards, or anything like that. Am I to understand that that makes them completely exempt from any FOIA action at all in the future once this would be taking place? And the second thing I would like to say is just a simple statement of there's no official anywhere, no employee anywhere at all in this building that was not elected, hired, appointed whatsoever, that's not actually a public servant, which is addressed in this document. And I always thought that meant a servant of the public, not any kind of a ruler of the public or over the public. And the book that I read in Matthew 23:11 says the greatest among you should be a servant. Thank you.
Thanks, sir. Signed up next to speak against the bill is Jester? Mr.
She had the lady.
She left, okay. Joey McCutcheon. You here, sir? There he is. If you would just have a seat at the end of the table, identify yourself to the committee, and a reminder you have 5 minutes, sir.
Joey McCutcheon,
Yes, sir.
Arkansas Transparency and Government Group. Feels like a little bit about David versus Goliath here, the people versus government. And that's sad. You know, that's sad that this feels like a well-oiled government machine today. This bill was filed on Monday. It's put on special session 2 days later on a Wednesday afternoon. This bill was filed at the end of the session with a week and a half to go by the power brokers of the state of Arkansas. Apparently, the people didn't know that the governor supports this, the attorney general supports this, Mr. Ray supports this, but we get it at the end of the session. That's not fair. That's not right. The FOIA task force was set up by this body in 2017 to protect the FOIA and to ask questions and to vet bills like this. A bill that will gut FOIA for records, especially for the poor folks, especially for the folks who can't afford $25 to pay for their records. That's not right. I don't care if there are 800,000 records. Maybe it's 800,000 records like occurred at Penn State University. I've had experience with Penn State University. I've represented 2 basketball coaches and their current coach now. Jerry Sandusky molested children year after year, and they had records that were similar to this. Mr. Ray tells us that he had another committee meeting. Mr. Ray is a political veteran. He understands that at the end of the session, you're busy. We set up a special FOIA meeting just to hear this bill. That's not right. That's not fair. That's where compromises occur. That's where bills like this are vetted, and they should be vetted. The FOIA task force voted unanimously, stating they were only not in favor of this, but it's not in the best interest of the state of Arkansas. And they're right, because these exemptions are large enough that you can drive a Mack truck through. Anytime you want to keep things out of the government view, just put on there that we're anticipating litigation, that we've talked to our attorney about this. We're entitled to see the sausage making, the deliberative process. That's what's meaningful to us. We don't want to see the final vote. We want to see the documents. We've done it for how many years now? The sponsor says he's proud that Arkansas has such a fine Freedom of Information Act, but he wants to prevent against those who weaponize FOIA. You know, I'm not a transparency but person, but I've heard that the entire session. I love transparency, but I am one of those persons who weaponize FOIA. I plead guilty as charged. And you know what I've discovered is that in Fayetteville, Arkansas, Isla Campbell discovered through records requests that critical race theory was going on. Kids in Huntsville, Arkansas, another case, through a FOIA request, we determined that kids were being sexually assaulted by other kids. You know what else? We've also seen in Conway, Arkansas, that transgender folks wanted records also. They wanted records when bathroom bills were going through. They're entitled to those records too. FOIA is not a conservative issue. FOIA is not a liberal issue. FOIA is not a Republican issue. FOIA is not a Democrat issue. FOIA is a freedom issue, period. It's a freedom issue. I've quoted the 1967 legislative intent. I want to ask you, is it really vital to a democratic society that government business be done in open and public? Let me ask you again, what have the people who voted for you, have you had just tons of them calling you and saying, we want to close, we want dark government. We want folks to have to pay for records. I mean, that's going to have a chilling effect. That's going to have a chilling effect on people requesting records. Everybody doesn't wear a suit and tie like Joey McCutcheon does. We've got people who can't afford to pay the electric bills, but they're entitled to 1 record, 10 records, or 100,000 records. Because you know what? That 800,000 records, that may prove that a child was being sexually assaulted. That may prove, we talk about the library bill that just passed through here. You know, I was involved in a FOIA case where I got documents involving the library in Jonesboro, Arkansas.
Mr. McCutcheon, 5 minutes is up, sir.
Thank you, sir.
Any questions from committee members? Seeing none, thank you for your testimony here today. Signed up to, I don't know if speaking for or against the bill, is Sergeant Van Thomas. Van Thomas, I guess, no longer here. Stephanie Friedman. Stephanie Friedman. Stepped out. I believe the last name is Cobb from Sherwood. Yes, sir. Sir, if you would just identify yourself to the committee. I believe you're speaking for the bill. Is that correct?
Yes, Mr. Chairman.
Okay, you're recognized.
My name is Steve Cobb. I'm the city attorney for the city of Sherwood. I just want to address a couple of the points. I'm sure there will be other individuals that are going to speak to different points. But with respect to a real-world approach, I just wanted to say that going from 3 days to 10 days would be helpful from the municipal level because a lot of the requests that we get, and this is not unusual, whatever specific topic that they're asking about will have the words all documents. Like I'll get an FOI request that says I want to see all documents on X project or road project. And all documents means that they're entitled to that, and we're going to get it for them, but it's going to touch on the city attorney's office, it's going to touch on road and bridge, it's going to touch on engineering, many, many departments that we have to collect information to comply. And when you get that FOI request, that goes to the front burner in terms of your attention of what you have to do and how you have to respond within that short period of time. If we're given a little extra time, I think that's going to be effective for cities to allow them to comply with the request, but at the same time carry on the task that they have on a day-to-day basis in terms of governing and what they're supposed to do in their jobs. So I think that would be helpful to municipalities, and I think there's other folks here today that are going to echo that they're from the municipalities. The other point I want to make with respect to the executive session for the cybercrime or the cyber issue, I have a real world experience in that. In the budget process in my city, our IT technician, our consultant, wanted to speak to that. They wanted to speak about some issues and some vulnerabilities that he perceived may be present in our city. And we couldn't talk about that except in very vague terms, which I think it would have been more effective and more helpful for us and for the citizens to have their information protected if we could do that in an executive session. So I think that just makes good common sense, and I would urge you to support those 2 points. Thank you.
Any questions from committee members? Seeing none, thanks, sir, for your time here today. Also signed up to speak for the bill is Jeff Hager. Chief, you would just identify yourself to the committee, who you represent, and you're recognized to give your testimony.
My name's Jeff Hager. I'm the Chief of Police at Sherwood Police Department, and I'm here to speak on behalf of the Arkansas Association of Chiefs of Police.
I'm Gary Sipes, Director of the Arkansas Association of Chiefs of Police.
You're recognized.
One of the individual that had to leave was with Little Rock Police Department. I wished he could have stayed, but he was going to testify about the number of officers that are dedicated at the Little Rock Police Department to cover all the FOIAs they get.
So the point that I would like to bring out to the committee, and I appreciate the opportunity to speak, is that, you know, I don't disagree with what a lot of the citizens have said in here about transparency and freedom of getting information. And I can tell you, you know, Mr. Cobb, our city attorney, spoke right before us, and he reviews all of these FOI requests that are presented to us. And the concern that I have as an administrator of a police department is the amount of resources that I have to put towards the filling of these freedom of information requests. We're not opposed to filling them, but I mean we get so many that are so open-ended that it really becomes a strain on our resources. I don't disagree that we are paid by taxpayers' taxes, but I will also tell you that what you're paying for my employees to do is to patrol, and my employees are being paid to protect our citizens, to not research and provide documents. I mean, that is part of our job, but it's getting to the point where I'm having to pour more and more and more resources towards that and less away from what we're being paid to do it, or what our mission is to be paid to do. So that's just my perspective, and I'll answer any questions that you might have.
Are there any questions from the committee? If not, we thank you for your testimony here today.
Thank you.
Next, we have Tim Reyes to speak for. Mr. Reyes, will you I'm sorry. Will you introduce yourself for the record, please?
Yes, Mr. Chair, thank you. I'm Sheriff Tim Riles in Faulkner County.
All right, you're acknowledged to go ahead with your testimony.
All right, thank you, sir. Most of the FOIA requests that we receive in Faulkner County can be accomplished in a very short period of time. The majority of them can be. However, there are times when it takes hours and even days and weeks on some cases to be able to, just depending on the nature of the request. FOIA is a system of transparency, and we firmly believe in and support in this system. However, our hope is to mold and to shape this law to best serve the citizens of Faulkner County. That's our entire desire here. Abuse of this system only prohibits a timely return of legitimate FOIA requests and place a burden on our already stretched and strained staff that's within our offices. We currently have a stack of FOIAs in our front offices as we speak that we had developed 7 months ago, and they're still in our front office, and we're still waiting for people to come and pick them up. And so there's some abuse that's occurring there, and that's one of the abuses that we have experienced. The request, it cost us time, man hours, which affect our already stretched budget. Keep in mind, at the same time, there were legitimate requests by our citizens and our media that were also waiting on their FOIAs to be answered while we were fulfilling these obvious illegitimate requests. In the past, we've encountered abuse of the FOIA where we had law firms that were trolling our booked-in page on our website who had been arrested the previous night before, and they would then FOIA the request of those that they thought would be a candidate for their defense. This is not what the purpose of FOIA is about. FOIA is about transparency. It's about everything that everybody has spoke about up here. I fear that the issues will continue without having some type of accountability or per se skin in the game to be able to counteract the cost or the amount of FOIAs that is being abused. I think this amendment addresses some of our concerns. That's all I have, Mr. Chair. Thank you, sir.
Thanks, sir. Any questions from committee members? Seeing none, we appreciate your time. Signed up next to speak against the bill is Luke Charlton. Sir, if you would just identify yourself to the committee and remind you have 5 minutes. You're recognized to give your testimony.
Yes, sir. Thank you. I'm Luke Charlton. I'm from Benton County, big proponent of transparency in government. I appreciate the opportunity to speak. I'm here today to speak against the HB1726. I believe it is a bold overreach of a self-serving government officials. The FOIA law was passed in 1967 in Arkansas. It's, as other people have said, it's one of the best FOIA laws in the whole United States. It's amazing. When I hear things about comparing it to other states, I don't want to lessen our FOIA law to just because some other state government was able to do it in their state. I don't want that to happen to our state. You know, we have recently been through a very trying 3 years. 2020 elections were very questionable. We've had a lot of regulations with COVID. We've had all kinds of concerns. Me as a person, as the general public, we have all kinds of questions. I think it's natural that these requests in times like these, they should go up. This is the whole reason why FOIA was created, for the concerned citizen to be able to look into these things and ask questions. It's made it this far with very few changes. We don't need to change all these things now. I understand the concerns about people trying to abuse it. That makes sense. But I also have friends that have asked 4 or 5 different questions in a FOIA platform who have been threatened with a harassment lawsuit by a government official. So it goes both ways. We, as the people, we get threatened as well. But I've never had any complaints from a person who has requested documents that have taken more than 3 days when the official has communicated that it may take more than 3 days, that they're working on it, that it's, it's something that's just a big request. When they communicate, there are no problems. It's when they don't communicate. When I don't get an email back for 5 days, for a week, not even a response to know that they even got it, and I email them back and they're like, oh, we never got it. Okay, maybe. Those are the concerns that I have. So yeah, I think why is there this increase in FOIA? I think it's because people they don't trust the government right now, so they're asking a lot of questions. That doesn't mean we should change the laws to snub the questioning. We need to fix the government. We need to change the things that we're doing so people aren't so concerned. I have a lot of notes here, and I'm trying to get everything out. Some of the notes I've taken earlier. Got that one. Oh, about the legal advice being paid. When I hire an attorney with my private money and I have that attorney-client privilege, I think that's fair. My question, if I was on this committee, if I was somewhere else, I would ask, well, are we going to give that same privilege to an attorney that's been hired with taxpayer funds for that person? I mean, I don't know. I don't know how it works, but that's one of my questions I would have. If it's taxpayer-funded attorney, for a public official, is that the same thing as an individual hiring that attorney for themselves? There was a complaint about exempting intellectual research of a university. Well, is that publicly funded? If we exempt that, is that hindering that research? Maybe a competitor gets onto that research too, and it furthers that research farther, and that's better for the general public. I don't know. Those are just questions I have. Why would we want to hide it if it was funded by the public? Why don't we hide that from anybody? Let's see. And yeah, my biggest concern with 1726 is the two things: the compensation. You want to charge the individual if it takes more than 8 hours. That's a huge deterrent for anybody to request it, because that might actually end up costing them money. So you're gonna get a lot less requests because people are gonna be fearful to ask. So that is going to take the transparency of the government, and that's gonna blur it. That's gonna make it less. And that's the opposite of what the FOIA is meant for. 3 days versus 10 days, the question was asked, and I was glad that has anybody actually been sued? I don't think this is a problem. Like I said, when you have the proper communication and people are saying this is going to take me 4 or 5 days, they're probably not going to get a lawsuit from some individual who doesn't have the time or the money or the capacity to hire an attorney anyway. I do also have concerns that it was not brought before the FOIA task force. I think that's a huge issue. I think the timing of this bill is bad, and that's all I have to say. Thank you, guys.
Thank you, sir. Any questions from committee members? Seeing none, we appreciate your time. Signed up to speak against the bill is Robert Steinbeck. Sir, state your name to the committee, and you're recognized to give your testimony.
Thank you, Chairman. My name is Robert Steinbuck. I'm a professor. I'm a lawyer. I'm on the FOIA Task Force, the FOIA Coalition. I'm the author of the Treatise on the Freedom of Information Act. It was good to see the attorney from the AG's office, my former student. He didn't mention that part, and he didn't mention that every one of his opinions quotes my book. This is the previous edition of my book, and on it are 3 authors. The second author is Richard J. Peltz-Steele. He's sitting right there. He lives in Massachusetts, but he's here at this hearing because of this bill. That's how bad. The FOIA Task Force has never issued an opinion as it did for this bill. They said this bill is not in the best interests of the state. They have never issued an opinion like that before. That's how bad this bill is. David Ray got up here and he skipped the whole first section. You know what the first section says? A governmental agency is an agency of the state. That means, hey, you folks, you sheriffs who showed up, don't worry. You don't have to answer any FOIA requests. This bill has exempted all municipalities and all counties from the FOIA in its entirety. This wasn't written by the ACA and the Municipal League? Let's go on to the next section. Then it says that, we want to put ongoing criminal activities. 20 years ago, the Supreme Court said that's in the law. So you want to put the word in, okay, but you're not fixing anything. Then the following sentence regarding law enforcement issues says, and any evidence or materials likely to be used by law enforcement in a criminal prosecution. Wait, what? What happens if I want to make a request of those cops that are in uniform, are good friends? By the way, I once served as an auxiliary police officer in another life. How did they get here today, and who paid for it? So I make a request, right? Well, if it's a municipality, no response, because this law has exempted it. If it's the state police, and then they say, oh, but wait, we may have committed a crime by coming here on our dollar, right? We're going to charge you for FOIA requests, but we can lobby for free. So we're going to come here and lobby, and so I'm going to make a FOIA request to find out. They said, no, we're not going to give you that. That might lead to a law enforcement agency investigating us for committing a crime. So that section is nonsense. Now let's look at I'm going to, in slightly reverse order, or in reverse order, this deliberative process. Deliberative process. Well, you said, well, you see, the governor has it, and the AG has it, all the constitutional officers have it, you all have it. Yeah, because you're not bureaucrats. That's why, because you engage in a deliberative process. But when the bureaucrats take away our rights, and all you want to show me is their final product, and then, by the way, all they have to do is send it through the attorney, and then it gets stamped attorney-client privilege, and you don't get it. You will get no records. You will get no records under this. Next section. I gotta love but if it takes more than 8 hours, then we're going to charge you. As Representative Ray tried to take the wind out of the sail, he said, well, this is just like a service fee, right? It's like a service fee when you go to court. You know how much I pay to file a lawsuit in court? $175. I get a judge, I get a bailiff, I get a jury, I get hours and hours and hours of work for $175. And these guys want to charge me per hour? By the way, what are they going to charge me per hour? Per hour of work from the person they determine to do it, or, wait for it, the contractor they hire. Under current law, they can't outsource government work, but under this bill, they can outsource it to a contractor. At what rate? Whatever the contractor charges. You think contractors charging minimum wage? $2.50 an hour. That's what a contractor's charging. Then they're going to say, well, we got to have our attorneys review it after all. Oh, are we going to use our inside attorneys like Ryan Owsley did? No! We're going to hire some big, tall building law firm that Ryan told you other people want to go work for, right? Go tell the governor it's not a good bill, right? So here's the thing, folks. Here's the thing. You want to fix the FOIA.
Your time is up. We appreciate your testimony. Any question from committee members? Seeing none, thank you, sir.
Thank you, sir.
Signed up next to speak against the bill is Ella Kreth. Ma'am, would you identify yourself to committee, and you're recognized for your testimony.
Thank you. My name is Ellen Kreth, and I'm the owner and the publisher of the Madison County Record in Huntsville, Arkansas. I'm a board member of the Arkansas Press Association. Thank you. Thank you for your time. I know the hour's late. I appreciate all the work that you put in on hearing both sides. I want to talk to you today about the practical implications of this bill on a very specific situation that happened in Huntsville just 2 years ago and has been ongoing. This is a real-world application to this bill. In early 2021, the Madison County Record published a story exposing the school board's attempted cover-up of player-on-player sexual abuse that had taken place in the Huntsville boys' locker room for 2 years. Multiple players were sexually assaulted by teammates multiple times. Upon learning of the assaults, the first thing the district administration, school board members, and personnel did was seek to cover up not only the assaults, but their failure to report the assaults to the Arkansas Child Abuse Hotline. Victims' parents, fearful that the district would not be transparent, approached the record and asked us to investigate, to hold the district's administration accountable. The administration refused to divulge what actions took place to keep their children safe or when they reported the abuse to the hotline. We were able to tediously piece together what took place in the district's cover-up and lack of actions through FOIA. We were able to find out by using FOIA that the board members and the administration found out about the assaults in early February. We found out by FOIA, and this is the part that's important, that they didn't contact their attorneys, attorney-client privilege, they didn't contact their attorneys until the end of February. Through FOIA, we found out that the attorney told them, hey, investigate first, report second. Because of being able to access documents and correspondence with the district's attorneys, we were able to show that the superintendent, the coach, the high school principal, and the athletic director failed to immediately report the assaults to the Arkansas Child Abuse Hotline. The superintendent and the coach were charged with failure to report. They pled guilty, and they're no longer employed with the district. This bill would have protected their behavior, kept secret from the parents the district's attempts at the cover-up of their malfeasance and their failure to report the abuse. This session, a lot of the bills have been about helping children. This bill harms them. This bill would gut FOIA and have allowed, and not only allowed, but enabled the district to cover up the administration's failure to report. Without access to the attorney's documents, the former superintendent, board members, and coach would not have been held accountable. I want to talk to you about the fees. In our situation, many of the perpetrators were affluent. The victims were poor. They didn't know they could access FOIA. We told them, go up there and get the records. Can you imagine if they had walked in and had to pay for documents in which their children's abuse was documented? Isn't that salt to the wound? This is the people's law. The poor should not be disadvantaged when trying to access documents. FOIA should not be turned into a rich man's law where only affluent have access to information and people are able to cover up their failure to report sexual abuse. Representative Crawford, may I address your question about the abuse?
Ma'am, you just need to, you can address it, but you don't need permission to do so.
Okay.
Just address it.
I wanted, Arkansas annotated 2519-105A3 says, the request for documents must be sufficiently specific to enable the custodian to locate the records. I know that people abuse FOIA. I get that. But if you want 10,000 documents, don't throw all of the document requests at one time. This law prevents that. If I were on the opposite side, I would feel very confident in saying, hey, your request was not specific enough for me to enable exactly what you wanted. And I understand under Arkansas FOIA law, if I made a request to you, you can't ask me why, but you can say to me, your request is not specific enough to enable our custodian to locate those documents. I understand that there is abuse. Let me just echo the people who have said today, this bill is being pushed through. I'm a huge FOIA advocate. I believe in transparency. I believe in respect for government officials, and I believe that there should be a way to work together.
Your 5 minutes is up. Any questions from committee members? Seeing none, thank you for your testimony here today.
Thank you.
Thank you. Wayne Beach, I see you made it back in the room. You have a seat at the end of the table, and you'll be...
Appreciate your reprieve.
Introduce yourself to the committee, and you're recognized to give your testimony.
First of all, I'd like to know if I can yield part of my time to Mr. Steinbach. But anyway, I don't know. Y'all, I've sat and listened to this, and I know y'all have too. And this is with just a short fuse of
Mr. Beck, I'm sorry.
I'm sorry. It should be Wayne
but
Beach.
The others may not. Introduce yourself to the committee.
I thought all y'all knew me.
Yeah, I'm sorry.
Anyway, I'm Wayne Beach.
Yes, sir.
I represent myself. But anyway, I've sat here and I've listened to this testimony. Some of it's been pretty good. Some of it's probably has some holes in it. But when I stand outside this door and you stand out there and you overhear a conversation from an officer that says, you know, these people got some good points. I got some good points. And I'm a little concerned. Let me tell you something. That speaks volumes, y'all. And I'll tell you, Robert, I walked in the room, and I walked in about the time he started in on it, and I'm sitting there going, yeah, this is the guy that wrote the book. This is the guy that actually was the other guy's teacher. And then he brings in somebody that's nationally known, that has actually fought these things, and are telling you that this is a bad bill. Let me recommend something. I'd like to recommend that you actually kill this bill now, and if there's things that we need to go in and address specifically, like the 800 documents or somebody that's abusing the system, that we address those specifically. We don't write a whole bill that kills everybody else's rights, that gives everybody else that right to listen and actually get the stuff that they pay for. I appreciate you letting me talk today. And by the way, I love all y'all. And that's all I have to say. Thank you.
Thank you, Wayne. Any questions from committee members? Seeing none, we appreciate you being here today, as always. Thank you. Signed up to speak against the bill is Rusty Turner. Turner, if you would, just identify yourself to the committee, and you're recognized to give your testimony.
Thank you, Mr. Chairman, and I appreciate your attention. I know the hour is late. I'll try not to be repetitive. My name is Rusty Turner. I'm the editor of the Northwest Arkansas Democrat Gazette in Fayetteville. I live in Rogers, and I'm also a past president of the Arkansas Press Association Board of Directors, and I'm speaking on the APA's behalf today. House Bill 1726 is a misguided bill that would significantly diminish the public's access to the workings of their government. The purpose of the FOI, as you have heard, is to expose government's deliberative process to the members of the taxpaying public so that they can evaluate government performance and the performance of the people elected or appointed to do government business. And this bill would clearly make it easier for government to operate outside the public's view. Shielding government deliberations and documents from public scrutiny would certainly make it more efficient. After all, without those pesky taxpayers poking around, life for government officials would be substantially easier. So would getting away with unpopular, inappropriate, or questionable policies. Without the safety, as you heard from Ellen Kreth and several other witnesses today. Without the safety net of sunlight on the public's business, government can operate without the check or balance of public opinion. The language in this bill would exempt large swaths of documents for public disclosure, documents that are currently available for inspection by any member of the public. It even specifically exempts deliberative documentation and communications between government officials, but the deliberations of government are exactly what the public is entitled to observe. With this bill, there would be little public input or debate. Decisions could be made in private, either in the old school smoke-filled room or on a Zoom meeting or with emails or text messages. The only thing that happens in public would be a rubber stamp vote. Is that efficient? Perhaps. Is it good government? No. In addition, this bill would make what few public documents remain available harder to get by allowing the government to charge what could be a substantial fee for performing basic government function. The FOI has been in force since 1967. The cost of providing government documents to the public should be baked into the budgets of government agencies. It is, after all, a basic function of any government. Now, I know this bill wants to address abuses, and certainly we can all acknowledge there are abuses. But as Ellen pointed out, there are also ways to deal with those abuses short of a law that disembowels the current FOI. From my perspective as a journalist, I can tell you that the FOI is a vital tool for us to perform our function as a check and balance on government power, as Ellen demonstrated earlier. Over the years, I've encountered hundreds of government employees and elected officials who want to do the right thing and are willing to provide the information to us that we know we're entitled to, and I'm grateful to all of them. But I've also encountered those who either don't care about their obligation to produce public records or worse, want to hide them. The FOIA has been the tool we've used to pry those documents free, and it allows us to keep tabs on the people elected or appointed to do the government's business. This bill removes that powerful tool from our toolbox. Our newsroom has covered dozens of stories over the years. I've been in this business 40 years. I've been an editor for 32. We've covered dozens of stories that we would not have gotten without access to government records, from coverage of the General Improvement Fund corruption scandal a few years ago to even a small story like a local jail who removed an inmate book cart for disciplinary reasons from the jail, but later claimed publicly that they did it as a pandemic precaution. The current FOI has allowed us to hold officials accountable in myriads of ways. It may be inconvenient for some officials who prefer secrecy to transparency, but it's good for the voters, it's good for the taxpayers, and you work for them. I urge you to vote no on this terrible bill. I'm happy to answer any questions.
Any questions from committee members? Seeing none, thanks, sir, for your time. Signed up next to speak against the bill is Chris Corbett.
Hey, Chris Corbett here. I'm a Conway attorney, and I like to call myself an alleged criminal attorney. If any one of y'all are arrested, I'm going to sign you up. I'm going to charge you some money. Let's say you got charged with the DWI. I'm immediately going to send a FOIA request for any video. The officers in here testified that that's awful. Why this is important, those videos were created with taxpayer money, and this is about taxpayer money. If they're spending taxpayer money, I get to see the product. I'll give you a short example. A client named Sydney was a bartender at Buffalo Wild Wings. She said, "You're a DWI attorney." I said, "Yeah." Well, I got arrested 6 months, I think she said 4 months ago, and she said, "It wasn't me. I wasn't driving." I said, "What? No way. They charged you the DWI? Let me pull it up on Court Connect." "Yep, you see it? Okay, I see it. I'll tell you what, I'll represent you for free if you weren't driving. Because I know in 3 days I can get the video." Versus discovery. Enter an appearance. You hire me. I'm going to defend you. Send in my discovery request. Wait 30 days. And guess what? If there's any prosecuting attorneys in here, they can turn that discovery file over when it's practicable. That's what rule, I think, 13 or 17 says in the Arkansas Criminal Rules of Civil Procedure, or the Arkansas Rules of Criminal Procedure. I got it quickly. I got the video. Guess what? She wasn't driving. I was stunned. And so let me read you the first paragraph in this bill. And this is how it's going to be interpreted. I know my time's limited. The first paragraph. Y'all should kill this bill immediately, right now. A government agency. They're redefining what a government agency is. Go down through it. It means office. Oh, hang on. My picture didn't work. Let me read it to you here. Government agency means an office, department, commission, council, board, committee, legislative body, agency, or other establishment of the executive, judicial, legislative branch of the state. That's it, period. This does not include county or the cities. That's it. You ought to table this thing, kill it right now, put it out of its misery. Just that first 3 lines, it's over with, right? So basically, is that what you want to do? You're for the people here. You're serving the people. There's been massive corruption exposed in the last 2 or 3 years in your body, sending legislators to jail, and now you're going to exempt county officials and municipal officials in the first 3 lines. It should be over with. I know my time's limited. There's a few other things down there. If you want to charge money, the 8 hours, 2 more minutes, the 8 hours, it says literally in further down in the bill, it says, or contractor. That's so simple. If a county or a municipal or a state hired me to defend a FOIA request, I'd say, hey, kick it to my buddy over here. He charges $3.50 an hour. So basically you're voting for the rich here. I've got rich clients and I've got poor clients. Miss Sydney, B-Dub was making minimum wage, and she didn't have the money to fight the FOIA request. They had to threaten to sue to get that video. I got the video. It wasn't her driving. That's just one example. I've done numerous FOIA requests, and they're real simple to answer the abusers. Put an amendment in here. There is some compromise. Put an amendment in here for a limited amount of time, and by a specific date. There's the people that request these FOIAs are reasonable. There are some out there that abuse it, but to come up here and hear the facts that are stated by some of the officers, why not do a legislative study to figure out what's going on with FOIA? FOIA is huge, and my last statement. Let me tell you how huge it is. You're going to limit the press to get the government records. The press needs those records to expose corruption. I don't have a barrel full of ink. Now it's an internet, and that's on the internet, right? I don't have a following of 3 million people if I find a document, right? But the press does, and they need that. They need y'all to defend them, and they need y'all to kill this bill immediately. And if you got any questions, Chris Corbett, I'm a Conway attorney in Faulkner County. Thank you.
Any questions from committee members? Seeing none, thank you for your testimony. Signed up next to speak against the bill is Scott Perkins. Scott Perkins. Signed up to speak against the bill is Luke Story. Mr. Story, if you would, just identify yourself to the committee, and you're recognized to give your testimony.
Mr. Chairman, distinguished committee members, you don't look tired, so I'm impressed. I appreciate the extended hour. My name is Luke Story, and I'm president of the Arkansas Broadcasters Association. And I want to acknowledge Representative Crawford's question. I think my colleague kind of indicated there is some existing codified language to help with that, but we do acknowledge that there are abuses and there are excessive, unreasonable requests. But I think from our interest as far as press and media, we're pretty flexible, we're understanding, and we feel like our requests are reasonable. There is a reason, I believe, when Governor Rockefeller signed our state's Freedom of Information Act law back in '67, that it was called the People's Law. It provides Arkansans with access and transparency to the way their government is run at every level. Our law, quite honestly, is held up nationally as a model that others look to of public policy that promotes sunshine government accountability and access for the people. Over the years, the law has been tweaked. We all acknowledge that, and in some cases, that may be warranted as technology changes or as new needs or issues arise. However, this bill would represent a sweeping change to our law and would dramatically impact the public's access to information. Section 2 of this bill, which we've hashed out over and over again, but says that any evidence or materials likely to be used by law enforcement in a criminal prosecution would be shielded from FOIA. That's an extremely broad exemption and could arguably apply to most anything associated with a crime or incident. And if it's determined, it may be used at some point. And to be very clear, I'm the brother of a state trooper, and media and frankly the public, we aren't asking for and don't need information that would jeopardize a criminal case. However, this exemption is vague, it's broad, and could be widely applied to shield information from the public. Section 3 of the bill It includes another overly broad exemption in shielding public records, government agency documents from the public. It would exclude communication between a public servant and legal counsel of an agency, including memos or documents prepared. And I think we all can acknowledge that this could be broadly applied to a wide range of public agency work and documents, and frankly, could be easily abused. While we believe the overwhelming majority of our public servants act in good faith and wouldn't do so, a quick way to evade FOIA for any government document would be to have the agency counsel review, give advice on, or prepare a document. It goes even further to apply to deliberative process records where opinions are expressed or policies are formulated. And again, that's arguably applied and could virtually be applied to all agency records. This bill goes on to impact the process for paying for and receiving records. And this adds an undue burden on citizens and the media and their access to public information in a timely and affordable manner. Government at every level operates best in sunshine. As media, it's our role to help provide that sunshine, and this bill keeps us from doing so. I appreciate the time. Glad to answer any questions.
Any questions from committee members? Seeing none, Mr. Story, appreciate your time, your testimony today. Signed up to speak against the bill is Dean Travinsky.
Hi, yes, thank you for your time.
Yes, sir, just identify yourself to committee and you recognize and give your testimony.
Thank you. My name is Dean Travinsky. I'm the Assistant News Director at KARK and Fox 16. I have also had the privilege of working under, I think all but, was it Hawaii's FOI law that Mr. Ray talked about, having a better FOI law than Arkansas? They aren't. I've worked in Texas, Oklahoma, Kansas, Missouri, Louisiana. All of those states don't want to release information. All of those states also have a current political official under investigation by a government agency. We don't right now in Arkansas. That's what an open, transparent government allows from the community's perspective. It allows them to gauge and judge what our elected leaders do and how that government works so that we can be informed and have valuable conversation about it. You want to look at two striking differences. Look at Uvalde and look at Nashville. Uvalde, Texas, they didn't want to release the school cameras or the investigations. Families went months not knowing what happened to their kids. In 2 days in Nashville, we knew. What's better? If it were your kids, would you want to know? Can those families in Uvalde pay an attorney to go fight for them? No. They need big, pricey lawyers to go up against all the state government agencies that are in there. So if you want to spend more than 8 hours to find a document, okay. So I'm paying for it anyways. Right? Do we have any overtime budget for FOIA right now? Is there any agency in the state that has filed or spent overtime on FOIA? I'm not aware of it if there is, but yet it takes all this time and energy to pull something up off of a computer. When does that clock start, by the way? Does it start on reception of the request? The end of the request? The moment they start to look for documents? But in my mind, the minute I get the request is when my clock starts. I've spent 3.5 years in Arkansas covering everything in this state. Helped build and launch the Working for You investigative team at Little Rock, KARK and Fox 16. We have removed a district judge because he wasn't being nice to his defendants in court. He was being rude. Asked the little old lady if she was deaf. Would have never known that without FOIA. Would have never been able to get that information. In fact, we've changed laws, so now the state is recording those hearings so that we can have access to them. I don't know, guys. Paying money, hiding, doesn't get the job done. Thank you for your time.
Any questions from committee members? Seeing none, thank you for your testimony. Signed up next to speak against the bill is Wesley Brown. Mr. Brown?
Chairman, everybody says.
Okay, thank you, sir. Signed up to speak for the bill is Mark Hakenmeyer. What is it? Hakenmeyer? Mark Hakenmeyer? He left, okay. Signed up to speak for the bill is Jay Cantrell. Okay. Y'all would just identify yourself to the committee, and you're recognized to give your testimony, and I remind you have 5 minutes.
Thank you, Mr. Chairman. My name is Jay Cantrell. I'm the sheriff of Washington County. With me, I have our staff attorney, Sam Martin. Listen, at the sheriff's office, our belief is that we are stewards of the public's money and stewards of the public's trust. And FOIA, I think, is part of that public trust, and having an open and transparent government is foremost in my administration. However, everyone's here discussing about their ox and what part of their ox is getting gored, and so we're here to discuss ours. And it's the part about what we believe is some of the abuse that's currently at least takes place at the Washington County Sheriff's Office. Some examples that we'll bring before you are agencies or media outlets that are for-profit, which I suppose most of them are, that recently FOIA'd a case that we worked, and we spent a large amount of manpower looking over that FOIA, got it prepared for them, got it to them, and then they, I mean a large amount, hours and hours and days, and they said, oh, well, we thought that was a homicide, it's not a homicide. Thanks for everything. So, you know, we expended a lot of resources, took a lot of people away from jobs that were probably more critical than that to fulfill this. Our staff attorney has prepared several incidents and things that he'll explain probably better than I can about what some of the abuses, but that's what we're here for, is to talk about those, and hopefully the committee can find a way to address some of that.
Good evening. My name is Sam Martin. I'm the law enforcement legal advisor for the Washington County Sheriff's Office. Just some high points on this one. Over our FOIA requests, starting in 2012, to highlight the issue, we had 375 requests. In 2013, we had 499. In 2013, 499. 2014, 635. Fast forwarding to 2018 and 19, we had 836 requests that came in, constituting 53.35 gigabytes of data, containing 4,441 files. By our rough estimate and math based on that file size, that's over 1.7 million pages of PDF documents. The high point of the year, 2018, 2019, 2020 all had over 800 requests. 2021 had over 1,000 individual requests and over 6.3 million pages of PDF documents that we requested on that one. And that's just document sizes on this one. As an example of our manpower issue, in 2021, the ACLU submitted a FOIA request to us. Our one employee only, the ACLU requested grievance petitions and medical questionnaires that our detainees had filled out. He had to do a specific keyword search and redaction on this one because it contained medical documentation. Took him full 9 days of his time on this, and approximately 63 hours of his time to just complete the redaction on that one example, on that one FOIA request. We have some other highlighted examples of cherry-pick some of our large FOIA requests. We've had 4 from the ACLU in August of 21, September of 21, and another one on September of 2021. We had 9,700 pages in the first one, 3,156 pages in the second one, and a few hundred in the third one and fourth one. We had one political advocate request to make 4 individual FOIA requests in that one. They constitute over 100 megabytes of data, several thousand pages of documents. Recently, as Sheriff was talking about, we had a media request on one of our cases. Just the documents alone in the main hours on this one, it was over 78,000 pages of PDF documents that we had to produce on that one. I think that covers some of our specific highlights on this one, and I don't know, Sheriff, you got anything else to add, or should we yield for
Well,
questions?
we are for the FOIA, and we believe that our documents are public, and we want them to be public. But some of these things take away our resources, and so I don't know if there's a way to compensate or to regulate or to mitigate some of those what we think might be abuses. But that's certainly our ox that's getting gored at the Washington County Sheriff's Office. So thank you, Mr. Chairman, and we'll answer any questions.
Thank you. Any questions from committee members? Seeing none, we appreciate y'all's testimony here today. Signed up to speak for the bill is Jim Hudson. Mr. Hudson. If you would, sir, just identify yourself as committee, who you represent. You're recognized to give your testimony.
Thank you, Chairman Tosh. Jim Hudson, Chief of Staff, Department of Commerce. Hours late. The room is pretty warm. Y'all ready to go? Just a couple of things very quickly just to give you a perspective from the agency's side of things. FOIA is very important. The teams that I lead stress to them we're going to be responsive as quickly as we can. It's good customer service. We work for the taxpayers, and so don't hold back. Disclose, liberally construe FOIA. We do want to make sure we're disclosing documents out there. I do want to address the deliberative process that has been discussed a little bit here. FOIA doesn't actually demand the deliberative process. It demands records. You disclose records. What happens currently is there's just a lack of production of records because everyone understands the implications of FOIA. That leads to bad policy analysis, and I think bad decision making because people are afraid to create a record. And so with having a little bit more flexibility in that would allow us to actually be able to document some of the decision making that is already occurring. So the deliberative process already exists in state agencies. It's just a truncated and a poor process. This would improve the process. Let me give you, for instance, on this. Department of Commerce, we're engaging with businesses throughout the state, trying to help them grow in the state. We have to be very careful about the information that they provide to us because it may be subject to FOIA. That does not allow for us to really kind of do good analysis in terms of policy to determine what parts of the state are growing, what parts of the state are not growing in terms of the economy. This would help us to be able to make better decisions. There was, I think, a comment was made a little bit earlier about proprietary information. One of the things that Arkansas struggles with right now is we lag in terms of venture capital. We do not see the same level of investment in terms of venture capital in Arkansas as we see in surrounding states. So if we're having a conversation with a business that's a startup, they're going to be reluctant to give us their proprietary information unless they know that's going to be protected. I cannot give them an NDA saying we're not going to disclose it because the state statute will compel disclosure. So what they end up doing is they end up holding back quite a bit. This would give us more protection to be able to have a conversation with the business about what their needs are and then how we can potentially meet those needs. Now, if we come to a place where we as a department identify a funding mechanism to be able to support that business and we take taxpayer money and we provide it to that business, that is absolutely a public document. Full transparency whenever we're spending the taxpayers' money. Firmly believe in that. But the process of gathering the data and analyzing the data, there needs to be more protection on that. And that's why I think the proprietary exemption is going to be very helpful to us if it passes. And with that, I'll take any questions.
Are there any questions from committee? Seeing none, thank you so much for your testimony.
Thank you, committee.
Time. Next, we have Jeff Rosen. I'm close. Speaking against the bill.
Yes, Jeff Rosenzweig. I'm a lawyer here in Little Rock, and I'm appearing on behalf of the Arkansas Association of Criminal Defense Lawyers. Some of the previous witnesses have hit on this, but I need to point out this could give carte blanche to a law enforcement agency to deny any request, no matter how simple. We're not talking about the 800,000 pages. We're talking about 1 page, 2 pages, that type of thing. undisclosed has always been in the law. Ongoing, although not in the law currently, there's the Supreme Court has sort of written it into the law, and there are a number of cases dealing with and a lot of controversy about what is ongoing. But this creates yet another category called any evidence or material likely to be used by law enforcement in a criminal prosecution. What sort of criminal prosecution? Where? When? At what time? And furthermore, the law enforcement doesn't do prosecution. The prosecuting attorney does prosecution. And the statutes in a lot of places, the Arkansas statutes distinguish between law enforcement and the prosecuting attorney. And so they can, slap secret on anything. Let me give you an example. Let's say I represent someone here in Little Rock, and he tells me he's falsely accused, and the false accuser has made similar accusations against a number of people in Helena. And so I go to Helena and file a FOIA, and I'm denied that because, well, it's possible that the Helena prosecutor may want to look at it, and I can't get that information. And why is that important? Because the Arkansas Supreme Court has said that the attorney has an obligation, as a professional obligation, mandated to do his own investigation. This is part of the mandated investigation we are required to do. The gentleman from the Attorney General's office said, well, they trying to not use the discovery process. Well, as Mr. Corbett said, sometimes the discovery process takes a long time, and sometimes when you try to use the discovery process, the judge will say, this is a fishing expedition. Give me some information so it's just not a broad investigation. That's what the attorney's investigation does, and using FOIA to do it so we can go to the judge and get an order under one of the other rules of criminal procedure to proceed further. So this will essentially negate FOIA with regard to law enforcement agencies if it's passed in its current form.
Are there any questions from committee? If not, thank you so much for your time and your testimony. Next, we have Michael Harry. Michael Harry, speak for. Mr. Harry, will you identify yourself for the record, and then you can testify.
Yes, sir, Mr. Chair. Thank you. My name is Michael Harry. I'm General Counsel for the Secretary of State. And generally, we are wholeheartedly for transparency in government. That's not been a question with our office. However, there is a provision in this bill that we are for, and that's dealing with the proprietary information. And I'll give you an example and a reason why. When we set out or give out notice of a request for proposal or qualifications to a vendor, most recently, say, the campaign finance reporting system, they'll send their responses to us, and in those responses, they'll have all of their trade secret proprietary information. We ask that they submit a redacted version to us that redacts that information out so that we can give that out, because we notify them that they are subject to FOIA once they submit that to us. Because the current exemption allows for protection of documents that would give an advantage to a competitor or bidder. So if we get requests for that, then we'll send out the redacted version. However, if the individual is not a competitor or a bidder, that exemption does not apply. Therefore, they are then entitled to a fully unredacted version of the response, which includes all of their trade secrets and proprietary information. It's a simple, easy workaround. I do not think that was the intent. That's how it was originally written. So that's why we are in support of this bill. And I'll take any questions.
Are there any questions from committee? Seeing none, thank you so much, Mr. Harry, for your testimony. Next, we have John Wilkerson to speak for. John Wilkerson, are you here? There you go. Mr. Wilkerson, if you will, identify yourself for the record, and you may go on with your testimony.
Thank you, sir. Thank you, committee. John Wilkerson, General Counsel of the Arkansas Municipal League. Of course, like everybody else that's come up here, we understand and appreciate the need for transparency, and I don't believe that this bill eliminates that transparency that's already required by the FOI. Like Mr. Owsley, cities, we train yearly, if more often than that, for cities and towns on the FOIA. And I haven't talked to Representative Ray about this bill briefly till yesterday, but the way I look at this bill is it's simply an attempt to find a balance between transparency and the need to keep government functioning properly. And it's that continuum that was talked about earlier, and I think this is a way to try to find that place in the continuum. So just a few quick stories that I've heard from cities and been part of from cities to try to illustrate some of the issues that we're dealing with that I think this bill, especially the 10-day rule, really addresses. We get cities that get, city in particular was emailed or FOI for every email that the mayor or city council sent for the last 5 years. To get that done in 3 days, of course, is impossible. I think the 10 days would help with that. We've seen instances of simply days before Christmas, where people are off work already, being FOI for requests that require multiple CDs, multiple videotapes or video CDs to be recreated, going through files to redact, hundreds, if not thousands of pages to be redacted in that short amount of time, requiring people to come back from their otherwise scheduled time off to help deal with this, that request. Repeated requests that have come in and documents that have been created, set in boxes, and an invoice is there for the person to come, pay the invoice, and pick up the documents that just sit there, and then get FOI for the same documents over and over and over, and with no one ever paying the invoice. So I think a lot of this bill, again, like I said, helps try to find that better balance between government functioning properly and efficiently, and the need for transparency. And like Representative Ray, I believe, said, it is that continuum that we're trying to find that sweet spot. The FOI is not meant, in my belief, to shut down government, and I think this bill tries to help make sure that FOI cannot be used to shut down government. So with that, that's all I have to say. Thank you.
Any questions from committee members? Seeing none, thank you for your testimony. Signed up to speak against the bill is Nate Bell. Sir, if you would, identify yourself, committee, and you recognize to speak against the bill.
Thank you, Mr. Chairman, members of the committee. My name is Nate Bell. I'm here today representing Common Ground, Arkansas, and I am speaking against the bill. I'd like to start with a metaphor, and I'm going to do my very best to be extremely brief here. Most of the guns that are present in Arkansas are not misused. Most of us use them to hunt. We use them for target shooting. We use them for home defense. We don't misuse them. We pass laws to punish those who abuse those firearms. You see, just because a freedom is abused by a few does not mean we should restrict that right from everyone else. It means that we should focus on those who abuse that right and make sure that they are held accountable for abusing it. Virtually everything that's requested under FOIA is because someone's suspicious of something that's happening in government. Ultimately, a lot of it results in becoming parts of investigations. In fact, when someone is submitting a FOIA, it is a citizen conducting an investigation on their own. When I served, we used FOIA to look into state agencies when they would stonewall us. A few former members of this body were prosecuted successfully as a result of some things that began with FOIA requests. Democracy dies in darkness. Sunlight's the best disinfectant. I want to close with this. Our state motto is Regnat Populus. The people rule. This bill is literally telling the people that their business is not their business. It's saying government wants their job to be easier, and we want to make it harder on the individual citizen to conduct their oversight of government and governmental operations. The state has vast resources at its disposal. if a citizen sends a FOIA request, I heard gentleman from the Attorney General's office say during the initial presentation numerous times that, well, they can just sue. Well, no, the ordinary citizen can't just sue for a remedy. They don't have the funds and the resources available to do that. The Attorney General's office can do that. The ordinary citizen can't. There's no balance here. At the end of the day, I just ask you to remember this. This bill's antithetical to our state motto. It makes it harder on the little guy and easier on government. The clear intent here is to restrict availability of information to dissenters. Again, sunlight's the best disinfectant. I appreciate your time, Mr. Chair. I appreciate attention to the committee. And with that, I'd be happy to take any questions if anyone has any.
Any questions from committee members? Seeing none, thank you, sir. We appreciate you being here.
Thank you, Mr. Chair, members of the committee.
Signed up to speak for the bill is Dale James. Mr. James, if you would, sir, just identify yourself, the committee, who you represent. You're recognized to speak for the bill.
Yes, sir. Thank you. Thank you for allowing me to be here this evening, and thank you guys for putting up with us for so long. I'll be as brief as I can be. I'm Dale James. I'm the county judge in Van Buren County, and we've heard a lot of good, honest, and legitimate reasons as to why FOIA should be 100% open, and I agree with those. All legitimate purposes for FOIA should be honored, and we should honor them, and we should give that information openly and as quickly as possible, and our offices really should be made out of glass. If you want information, you should be able to get it. But there is a negative side to FOIA as well. I'm going to yield some of my time to a fire department that is within my county. And the fire department is going to talk to you today because, as a favor to me, they did not disband due to some harassing and overwhelming instances of FOIA requests at the hopes that something might happen down here that would help them, help protect them. We have within Van Buren County a small city of Fairfield Bay. It's a retirement community. It's the kind of community on the lake that everyone loves. They want to come and swim and boat and recreate in all types of different manners and enjoy God's gift to us. Occasionally, accidents happen, especially on the lake. And the mayor had a team of 3 OEM, which is Office of Emergency Management, people who were fully trained, who had worked in various aspects of OEM, had come to Fairfield Bay to retire, and they volunteered their time. Due to the harassing and the inundation of the harassing FOIAs, we lost that OEM staff. They stepped down. That doesn't serve the people. That doesn't serve the taxpayers. I truly agree with most of the instances that have been brought out today. Absolutely, FOIA should exist. No one here wants to eliminate FOIA. We love sunshine. Sunshine is a great disinfectant. It's when that sunshine becomes sunburn that we need to say that it's just like when free speech becomes hate speech. There is a time when we have to make a decision that we've got to do something. And with that, I appreciate your time.
Thanks, sir. Any questions from committee members? Seeing none, thank you for your testimony. Signed up to speak for the bill is Donnie Harvick. Sir, if you would y'all would just identify yourself to the committee, and you're recognized to speak for the bill.
Thank you, Mr. Chairman. I'm Donnie Hovick, the Fairfield Bay Fire Chief, and I'm here to speak in favor of the House Bill 1726. We're a volunteer fire department. And we work with Van Buren County and Cleburne counties. We provide fire, medical, and emergency management services. While I draw part-time salary, all others members are unpaid volunteers who serve their community unselfishly. Over 17 months from 2021 to 2023, we received 144 FOIA requests. 99% were from one person who had an axe to grind with the city administration at that time. We answered all of them, consuming many hours of the city clerk's office and many hours of our people on the fire department. And we answered every one of them. 49 requests asked for the fire department roster and other documents, many the same as the requests they did a week ago. 95 requests were from the general fund and financial information regarding the fire department activities, again, many times for the same documents, repeatedly. Some documents did not exist, yet we were asked repeatedly. Time had to be taken to redact phone and email information from the department roster. All documents had to be produced in the requester and the FOIA file, causing a great deal of copy work. We were unable to charge the actual cost for the number of copies and the labor for those copies. All the information was provided. It could have been provided by a phone call or a call to the officers or a call to me. We didn't need to do the FOIAs. Those are the tangible impacts. Here's the rest of the story. The impact on volunteer morale was serious. Personnel was reluctant to communicate with each other to the city hall in writing. Whatever was written was spoilable. Personal phones were open season if a volunteer communicated with any department and city business. My phone was FOIA'd twice. Volunteers began to question their value and effort when weighed against the constant FOIAs, as well as accompanying barrage of vile social media posts. Some members retired early or just resigned. Toward the end of 2022, the city FOIA requests for the names and contact information of members of the extremely successful search team and OEM, that's when they all quit. They didn't want that to happen, so they just said, we're done. We don't have to do that. They were all awesome employees. It was a private organization, but they worked for the city. When they were confronted with the FOIA to provide the information to the same set of people who were bombarded the city and the fire department, they quit. We lost a valuable asset that helped out the whole community. We vigorously support the concept of transparency in city government operations. We support the concept of the FOIA. And we encourage the state to take action to limit the use of FOIA's concept as a tool for revenge and harassment. And this was definitely harassment of organizations or officials. The hard costs are significant. The redirection of valuable time for volunteers is also significant. And the impact on the morale of volunteer spirit is truly a problem. Thank you for hearing us today. Do you have any questions?
Thank you, Chief. Any questions from committee members? Seeing none, we appreciate y'all's time before the committee. Okay, next on the agenda to speak for the bill is Director of State Police, Colonel Mike Hager.
Good evening, Mr. Chairman. My name is Mike Hager. I'm Director of Arkansas State Police and Secretary of Department of Public Safety.
Hugh Finkelstein, Chief of Staff for the Department of Public Safety.
You're recognized to speak for the bill.
Thank you, sir. As it's been stated repeatedly, we believe in transparency in the spirit of FOI, but want to address the reality of what it's become in regards to DPS and specifically to the Arkansas State Police. Pursuits have risen, and this has created a for-profit opportunity for social media vendors. As a result, we've had to assign 3 full-time employees, to include 1 attorney and 2 staff members, to support the financial gain of these vendors. Just one such vendor currently has 4.4 million subscribers. While generating an untold amount of revenue for these vendors, it's created a significant drain on our resources funded by our tax-paying citizens. Secondly, this creates a disservice to the defendants in cases that have not been adjudicated. One recent pursuit had 24,000 views in just 2 days after being released by FOIA. To put that in perspective, the agency has 5 days to review and submit the packet through the chain of command because of the time necessary to compile and review the documents and to make administrative recommendations. If that defendant were my son or family member, I'd want them to have their day in court prior to this being put on the platform for the public to see. Lastly, because we believe in transparency and we're concerned that the current abuse of the FOIA due to its broad application, it hinders us from satisfying FOIA requests in a timely manner as it relates to its intended purpose originally. With that, I'll yield to Mr. Finkelstein.
There were some really good questions. Thank you. There were some really good questions asked, and gentleman behind me asked, is it fair to have an attorney-client privilege for attorneys who are paid by taxpayers' money? And I thought, that was a good question, but then I remembered that public defenders are paid by taxpayer money, and they absolutely have and are entitled to the attorney-client privilege. Before I was chief of staff, I was chief legal counsel, and we, oddly enough, we get sued a lot at DPS and ASP, and we have to have very frank conversations about what to do with these lawsuits, if we can settle, how much we can settle for. All of that is FOIable. Our whole strategy, what we can do with these cases is all subject to disclosure, and it should be protected. And with that, I will yield.
Any questions from committee members? Seeing none, we appreciate y'all's time before the committee today. Thank you for your testimony. Signed up to speak against the bill is Sonny Albardo.
Thank you, Mr. Chairman. I'm Sonny Alvarado. I'm here speaking on behalf of the Arkansas Freedom of Information Act Coalition, which is a private group composed of print, broadcast, and online journalists, lawyers, private citizens, and some public officials, all of whom support open government and seek to preserve and protect the public's right to know as provided by the Arkansas FOIA. Everyone who's testified today has pretty much said what I had intended to say, so I'm just going to leave you with this thought. I don't think a single person who spoke for this bill was a private citizen. They all represented specific interests of public agencies. I think the voice of the citizens should be heard. My own position on this bill is that it deserves further study. It deserves for all of the stakeholders involved, the public agencies, citizens, to be able to hear and discuss the things that were discussed today and address specific problems with the FOIA, not a blanket exemption as this bill does. I appreciate your time.
Thanks, sir. Any questions from committee members? Seeing none, we appreciate your testimony. Signed up to speak against the bill is Paul Calvert. Sir, if you would just state your name to the committee and you're recognized to speak against the bill.
Thank you, committee. My name is Paul Calvert. I appreciate your time. I know it's getting late. There's really only one issue I'd like to address on this, and that is the attorney-client privilege for government officials. And so I guess he was the representative for the Public Safety Commission, or I can't remember what his agency was. He was making the point that yes, that public defenders are tax funded, but their clients are not on the clock. Their clients are individuals who are being prosecuted, sometimes mistakenly prosecuted, and this is a service provided by the state to help them exercise their right to an attorney. And again, they're not, the clients themselves are not on the clock. When a state trooper is receiving counsel that is taxpayer funded, the trooper himself will more than likely be on the clock during that counsel period. And so there's a difference there. He's acting in his official duties, whereas the person who's being prosecuted and receiving benefit of the public defender is not on the clock. They're actually probably losing time at work. They might literally be in jail while they're being held awaiting trial. And so they may be losing all of their assets because they can't pay their bills, whatever it may be. So there's quite a difference between a public defender and having that attorney-client privilege versus a government employee and having that attorney-client privilege. When it's a government employee, every bit of that communication is tax funded, from what I can tell, because the employee is on the clock and then the attorney is on the clock as well. And so we're paying for every bit of that. That's all I want to say about that issue. The other issue is I want to offer a solution to some of these problems. I am sympathetic to the issue of people weaponizing the FOIA laws and just basically brutalizing some of these agencies with just tons and tons of requests. My solution is to that, let's go ahead and do kind of like what they've done at the circuit clerk's office. They used to, if you needed to go find a record for a real estate record, you had to drive down to the clerk's office and they'd have to dig through all the files and they'd find that record for you and you'd maybe copy it on a copying machine or something. Today, you know what we can do? We can pull up on our computer and look up those records anytime we want to. We can, if we want to look up 1,000 different properties, we can. And we just spend our own time, and it doesn't inconvenience the public official at all. And that's the solution. That's the solution to this. These are public records. Make them available to us. Make it a habit. Automatically redact everything that needs to be redacted, and publish it. Put it on the internet. It's cheap now, and it needs to be going. It needs to go on the record for everybody to have access to, and it will solve this problem. Yeah, you'll probably have to hire some people to do that, but when you do it on a regular basis, it becomes a lot more efficient and streamlined, and you may actually spend less time doing it if you just go ahead and do all of it. Thank you.
Thanks, sir. Any questions from committee members? Seeing none, we appreciate your testimony before the committee. Is there anyone else that I failed to call your name that I've overlooked you that was signed up to speak for or against the bill? That's the last one I had on my list. Seeing none, Representative Ray.
Committee, thank you so much for your time and attention to this today. I know the hour is getting late and we've listened to a lot of testimony. I do have a few things I want to say as we wrap up. I appreciate everyone who came here today to debate and offer input on this. You know, this has been an interesting bill because many of the people who came to testify against it are actually friends of mine. So that's a little bit odd. But some of the testimony that you heard today was just histrionics. And I'm not going to try to compete with some of the exaggerated behavior just designed to elicit attention. The idea that this bill somehow kills FOIA is just patently false. That's not true. If you'll remember back to the beginning of my presentation, how I opened, talking about the continuum between the black box and the fishbowl and the 1,000 points on the continuum that exist between there, what we are debating is just where individual aspects of records ought to fall on that continuum. This bill does not say that government will be a black box that is closed to citizens. That is just simply not the case. It was said that this bill eliminates FOIA for cities and counties, and I just want to correct that because that is patently false. It's inaccurate, and I'm just going to walk you through the bill if anyone still has that concern. So if you go to Section 3, where we talk about attorney-client privilege, the terms here that are used on line 26, page 2, governmental agency, line 24, public servant. These are terms which on the first page in the definitional section apply to the state. Those apply only to the attorney-client privilege exemption only applies to the state. Same for the deliberative process exemption on page 3. Line 4 uses that term, governmental agency, which is defined as the state, back on page 1. Other provisions apply throughout FOIA, like the time extension on the response time. So I just want to point that out. The FOIA definition in 2519-103, where it defines what is included under FOIA, this bill does not change that definition at all. That includes, quote, agency of the state or any political subdivision, including municipalities and counties, boards of education, et cetera. As you heard from the presentation from the Office of the Attorney General, these changes that are being proposed are not foreign or novel. They are changes that exist throughout the states, in states across the country, in FOIA laws across the country, including in conservative states. The reason that we're proposing these changes are to benefit the public, to conserve tax dollars, to improve efficiency in delivering basic services like public safety, like fire protection, like you heard about, and to ensure we have rule of law. That is why this bill is supported by the governor. That's why this bill is supported by the Attorney General and the Secretary of State, and virtually unanimously by law enforcement, from state police to Sheriff's Association to chiefs of police. I'd appreciate a good vote, and I'm closed for the bill.
Committee members, Representative Ray has closed with the bill. Do I have a motion? Representative Bentley. Representative Bentley has made a motion of, just a minute. Has made a motion of due pass. Is there any discussion on the motion? Representative Womack, you're recognized for discussion on the motion.
Thank you, Mr. Chair. I'm just going to address a few things that I picked up in testimony, nothing that was actually in black and white in the bill. Just some notes I jotted as all this testimony was going on. Literally everybody that testified in favor of this bill stands to potentially benefit from keeping sunshine out. And the officer earlier, that very early in testimony, and I didn't catch his name, but in the uniform, made a comment about people having skin in the game. That was a little out there, I think. Everybody that files a FOIA request has skin in the game, through taxes, through providing his income, through their time, through their effort. I thought that was a little out of line personally. We've heard about if these agencies have to spend time and money doing things, which are all tax dollars, by the way. That's okay. Some things are worth paying for. We use tax dollars all the time. There are things worth paying for. So if it costs some money to help shine this light, I think that's totally appropriate. Mr. Hudson said that people sometimes are afraid in these agencies to generate records. Well, that shows me that it's more important that we have quick access to the records that do exist. if there are things that we know may not be being documented, it makes the things that are documented far more important. And everybody that served in this body, I think, understands we're not experts at everything. There are things, we have areas of expertise that we understand these issues inside and out, but we deal with the vast majority of the things we deal with, we're not experts in. We literally have the men that wrote the book on FOIA sitting in the room, and they unanimously tell us, this is a bad bill. I think we should listen to those people. I will be a no on this bill, and I hope and pray that everybody else on the committee is. Thank you.
Representative Womack spoke on the motion. Representative Crawford, you're recognized to speak on the motion.
Thank you, Mr. Chair. What an evening. What I would say is let's work to find a balance. Abuse is happening. We heard it. That needs to stop. But let's find the right sunscreen for the sunburn. Let's not get rid of the sun. And so I say that because the people matter. You guys, we're here because the people brought us here. And what I would like to see happen is that this go an interim study, that we work really hard to get rid of the abuses. There's got to be a way. I'm not the expert, don't claim to be, but there are people here who are. Let's find a way to work together so that the volunteer fire departments don't have to go through what they went through. That should be illegal. But there's a way. I truly believe that in the United States of America, in the great state of Arkansas, we can find something where we can work together. And for that, I'll be voting no.
Representative Crawford has spoken on the motion. Any further discussion on the motion? Seeing none, I have a motion of due pass. All in favor say aye. Aye. All opposed say no.
No.
Roll call.
Representative Meeks. Representative Meeks. Representative Jean.
No.
Representative Jean, no. Representative Wardlaw. Representative Wardlaw. Representative Miller. Representative Miller. Representative Womack.
No.
Representative Womack, no. Representative Bentley.
Yes.
Representative Bentley, yes. Representative Gonzalez. Representative Gonzalez, no. Representative Beck.
Yes.
Representative Beck, yes. Representative Richmond.
No.
Representative Richmond, no. Representative Gazaway. Representative Gazaway. Representative Crawford.
No.
Representative Crawford, no. Representative Scott.
No.
Representative Scott, no. Representative Clowney.
No.
Representative Clowney, no. Representative Milligan. Representative Milligan. Representative Carr.
Yes.
Representative Carr, yes. Representative Underwood.
Yes.
Representative Underwood, yes. Representative Berry.
Yes.
Representative Berry, yes. Representative Moore.
No.
Representative Moore, no. Representative McElroy.
No.
Representative McElroy, no.
Representative Ray, your bill has failed.
All right, thank you, committee, for your time and attention. Appreciate the debate.
Committee members, we have another special order. Representative Bentley. Yeah. Committee members, there's a handout Representative Bentley's got. We're fixing to distribute that, and then we'll get into the bill. Next item on today's agenda be House Bill 1610. It's by special order. Representative Bentley, if you're recognized to present House Bill 1610.
Thank you, colleagues. You know, we debated this bill for 3 hours before we went on spring break. And at the end of that, I had some colleagues that asked me to go and visit with the FOIA task force, which I did. I met with them twice since we went on spring break. And at the end of the session, I guess 2 or 3 of the members asked us if we could come to a compromise, and exactly what I bring before you guys today. This bill is amended as a compromise from what I had before. If you'll remember, I had a quorum of, and if you look at the handout that I just gave to you guys, in 47 states across the nation, we have the definition of a public meeting is a quorum of or majority of. And so the original bill that I brought to you matched what those 47 other states do. And in compromise, I brought back to you, and if you'll look at the amended bill, it says more than 1/3 of the members of the governing body will constitute a public meeting. So that is a compromise from what I brought to you guys before. I just think it's a tragedy that we don't allow our state, our city and our county elected officials to have the liberties that we do to call each other on the phone. So what this bill will simply do will allow a JP, if he has a question about an ordinance that another JP passed, to pick up the phone and call them. I don't think it should be against the law for that JP to pick up the phone and talk to another JP on the phone, to allow them to visit, just like you and I do every day, whether we're in session, whether we're out of session. We talk to each other about things in our district, things that are going on in our counties. And I know that we can have good government, and that's what this is about, is producing good government. I think that too many people think that everybody's elected is wicked and evil and trying to do dark things around the corner. I've seen so many posts about wicked and evil things that are going to occur. But we've got good people that are elected, just like you and I have. And so we have people that have been duly elected by our constituents, and I believe for the past 57 years their hands have been tied. We have an imbalance of power where the county judge and the mayors and those can all visit, but our JPs cannot, and our city council members cannot. And so it's really been inefficient and ineffective, and an imbalance of power that we've had, and that's what I'm trying to correct with an amended bill with some compromise. And I just really think we need good government. We need our constituents to be fully represented by those that have been duly elected by them to do good things in their counties, just like we do here in the state. I think we've done a great job this session. I'm proud of the work that we've done. And I want good things to happen in our counties. And I'll again remind you guys of what happened in my district, where it's 2 years for the JPs to be able to fix an ambulance situation, a very serious situation, because they could not talk and communicate like you and I do all the time. I want to talk about school board members for just a minute. School board members are not paid. They're pretty much volunteers, but unfortunately many of them get sued because they talk to another member. Someone thinks they're talking to another member about something, so they end up getting sued. by other folks, and we have people drop out. We have some parts of our state that can't even get somebody to run for school board. It's a non-paid position. They're being sued, and who wants to go through the hassle of what they have to go through as school board members? So in my eyes, we need good people running for office, and we've set up some hurdles that are keeping good people from wanting to be in public office because they're harassed for talking to a friend of their neighbor at the ball game or whatever. They're being sued left and right. It's just not necessary for what's going on. So to me, this is a simple process. I have people tell me all the time this is being already violated. Well, then the only people that are not being allowed to talk are those good people that are doing good things for our constituents, and I think that this will allow for good government. It'll allow for our constituents to be represented better, for those JPs to do like you and I do every day. We talk to each other and make good things happen for our constituents, and that's the heart of my bill. I want those JPs and those school board members to be able to do as well for their constituents like you and I do. Again, it's simple. 1/3 of the governing body can meet without being a public meeting. Again, if you look at the handout that I sent to you, 47 other states require a quorum of a majority of it to be a public meeting. So we're again stricter than 47 other states across the nation. And with that, I'll take any questions if you guys have about the amended bill.
Any questions from committee members? Seeing none, we have 18 people signed up to speak for or against the bill. Representative Richmond, you have a question?
Yes, Mr. Chair, I'd like to make a motion.
Let me hear your motion.
I make the motion that we limit debate to 15 minutes, both sides.
Limit testimony?
Yes, testimony.
That is that's a proper motion. It's non-debate. It's non-debatable. Let me hear your question.
15 minutes each side or 15 minutes total?
Each side. 30 minutes total.
Okay. That's 15 minutes for each side, 15 for those for and 15 for those against. Is that correct?
That is correct.
Okay.
And it is not.
So that is. That is a proper motion. Non-debatable. All in favor say aye. Aye. All opposed say no. Okay. The motion has passed. Each side be limited to 15 minutes. So first on the speak against the bill is Jimmy Gavin. Mr. Gavin, there's several people signed up to speak against the bill. Y'all have a total of 15 minutes total.
Yes, sir. Yes, sir. I'm going to try to be as brief as I can. With the amendment, we now have a new legal question. With bodies of 13 like my quorum court, that would mean 4 1/3 members could meet. If you have a body of 10, that's 3 1/3 member. If you have a body of 8, that's 2 2/3 members. Body of 7, 2 1/3. Body of 5, this is where it gets interesting. Body of 5, 1 2/3. Body of 4, 1 1/3. Not only is that crazy math, but what do you tell the bodies of 5 and 3? When other bodies, you have multiple people can meet, now the bodies of 5, you say, okay, but you're out. Now, what this amendment doesn't do is address that math. Can you round up? Do you round down? What do you do with 2/3 of a member? What do you do with 1/3 of a member? The amendment gives us nothing on that. No clarification. Ms. Bentley's amendment also seeks to cure a problem that does not exist. That there is no balance of power between city councils, quorum courts, school boards, and between mayors, county judges, and superintendents. The mayors, judges, and superintendents, she contends, have all the power, and that doesn't fly in the face of Title 14 and Title 6. Which I have if anybody wants to read. I did read them. The mayors and county judges have zero power over councils and quorum court members. They are separate branches. As far as superintendents, the board hires and fires them. So you do the math on that. Now let me tell you why this amendment will actually create an imbalance of power. And my Conway School Board is made up of conservatives. Now in May there's an election, and if 2 liberals are elected, then this law will allow conservative members to meet in secret and create policy or deal with any issue, show up to the public meeting, and present and vote on things without ever letting the two liberals give input. Contrast that with the Little Rock School Board, who could now do the same with the conservative members. But take political parties out of it. Majority alliances can be formed for whatever reason and leave the minority of those governing body members completely out of the process. We all remember how Obamacare was created, right? Every bit of it behind closed doors. Pelosi said that we have to wait to pass it so we could see what's in it. That's exactly what this amendment will allow these bodies to do on every issue. Does that sound conservative to you? Quorum Court member Andy Schock from Faulkner County. Well, I know I would not abuse this, nor would I think any of my colleagues would. I couldn't be sure there are others in the state that wouldn't, so I oppose it. I can see her reasoning, but I can also see how it could be abused. Justice of the Peace, Jason Lyon, thank you for reaching out on this topic. As submitted, I'm very much against HB1610 as it will lead to expanded issues with deals being done behind closed doors. Justice of the Peace, Johnny Tyler, not okay with that. Again, I love Miss Bentley, but I'm a citizen first. I love that. So I'm going to say it again. I am a citizen first. I want all of our elected leaders to have to say what they need to say in public. Besides, I enjoy it more when we talk business in front of the public because of the feedback. Cindy Webb, Conway City Council member, against it. David Grimes, City of Conway Council member, against it. Those are the very people that we're talking about. I would also say that go back to who do you represent and who do we represent? It's our freedom and right to hear it is guaranteed in the act. And I want to ask a question of this body or anybody. Please tell me what is conservative about this. I've asked this question to legislators, senators, representatives, please tell me what's conservative about this bill when you apply it to the intent of the law. And thank you. With that, I'll take any questions.
Stop the timer. Any questions from committee members? Seeing none. Signed up to speak against the bill. Oh, well, how much time is left for against the bill? You have 10 minutes left to speak against the bill. Mr. Gavin used 5 minutes. So Dennis Scroggins. Scroggins, I remind you, have 10 minutes and 25 seconds left, and there's still several other people signed up to speak against the bill.
Thank you, Mr. Chairman. I'll talk fast. Hopefully we can listen fast. 62 years old, grew up in Truman, Arkansas. I can remember Singer Company used to run the city of Truman, and basically this law says greater than 1/3. So that means up to 1/3 inclusive. People could meet, 3 of those, say up 9 people, 3 could meet at the Pizza Hut. At the same time, 3 could meet at McDonald's, and the other 3 meet somewhere else. What are they going to do, swap up and later on meet somewhere else in a different array? So they have just held a meeting in secret, and that's exactly what they used to do in Truman, Arkansas. That's all I got.
Thank you, Mr. Scroggins. Stop the clock. Any questions from committee members? Seeing none. Signed up to speak against bills, Roger Kidd. Roger, you've got 9 minutes and 49 seconds left.
Yes, sir. Roger Kidd, Jonesboro, Arkansas. Love me some Miss Mary Bentley. I'm real brief here. I've got 13 JPs. So this would mean 4 point something could meet privately. Well, right now, most all the time, nothing is discussed in my quorum court meeting. Most everything is read off and voted on immediately. This means this amendment is already happening. It's already happening. So we aren't enforcing what we have now. Now, I want to say this, and I'm going to say one more thing. I'm involved in several groups, and some of you know, Mr. Chair, around my area, and this will create chaos and resentment against you good people here that I know, and I don't want that. And one more statement. What did Jesus say a quorum was? What did Jesus say? He said, when there's 2 or 3, I'm present. So for me, that's the definition of a quorum. I thank y'all for your time. It's late. I've been ready to go home for 3 hours. Bless you.
Okay, stop the timer. Signed up to speak against the bill is Lori Justice.
She's not here.
Is Justice still here? She already leave. Scott Gray.
He's not. He had to go to a different.
Scott Allison Gray. Ms. Gray. You got 8 minutes and 30 seconds.
Yes, sir.
Roger was pretty fast.
My name is Allison Gray, and I strongly oppose HB 1610. FOIA brings light to the darkness within government. Without FOIA, concerned citizens would be clueless about what is truly going on in their government. This bill allows less than a third of a quorum court, city council, or school board to meet in secret. This will undoubtedly result in secret meetings where deals are cut behind closed doors. It would be relatively easy to have a go-between among groups of members to discuss what should be spoken about in front of we the people, and what they decide to hide from us. With these decisions being made in advance behind closed doors, government becomes opaque. Although secret meetings might already be taking place, why legalize it and therefore encourage the practice? Thank you for my time, and thank y'all for staying here.
Thank you. Signed up to speak against the bill is Mike Modis. You have 7 minutes, 39 seconds.
Thank you, Mr. Chair. My name's Mike Matos. I am speaking. Thank you, Mr. Chair and the committee. I know it's late, and I will try to be very brief. My name's Mike Matos. I'm here in my own capacity, but I do serve as a city council member in the great city of Valonia, and I oppose this bill. And I've heard a lot of rhetoric. There's a lot of things I can't get into because my time is limited, but I've heard a lot of rhetoric that this is the same, this would provide the same liberties to the local level government that you all are provided as state representatives and as our senators are provided. And I think that's an apples to oranges comparison. Up here, as y'all can see, we just spent 4 hours on one bill that failed. It never made it to the floor. If it would have made it to the floor, there would have been a whole, maybe 2 or 3 other committees it would have to go through. And so that's not the way it works on the city government level. 99% of the time, there is a resolution or an ordinance that's usually brought forth by the mayor or the judge. It's brought to us. There's very little to any discussion at all. And it's passed or it's failed within moments or minutes. As far as talking with one another, I can talk to all of the city council members that I want to talk to about any type of business. We just need to do it in front of the people. And the question that I would ask everybody is, what is so important and so secretive that the business that I was elected to do is not done before the people? And, you know, here's the thing. What this will provide is a body of my size. I have 6 members on my committee or on my council. It would allow 2 people to get together over here on the side. I tend to be an opposing voice. Okay, so I'll just use myself as an example. But 2 people over here could meet privately. They know Mike's not going to be for this. They can hash out all the details. And then 2 other people can meet, hash out all the details. Mike's never brought into the loop. The public's never brought into the loop. And then we get to, before the public, somebody could make a motion to limit debate. The opposing voice never gets to speak. It doesn't work the same on the local level as it does on the state level. It's just a different type of government. And so I do have a solution if we need to. And I also heard about the mayors and the judges' powers and the balance of powers. I think I have a solution to that. I don't think 1/3 is a solution because we have a municipality in Holland, Arkansas that has 3 council members. How did they get to take advantage of this bill? Or in our great friends over in McRae, Arkansas that only has 4 council members. How do you have how does 1.33 people meet? So they wouldn't be able to take advantage of this. My suggestion to this would be, if it's important for us to follow the other 47 states, if it's important to limit the judges and the mayors, my suggestion would be amend this bill again, take away the words more than a third of the members thereof, and replace it with these words: 2 or more members, including the chairperson. That will define what constitutes a public meeting. It will also balance the power to where the mayor and the judge isn't out talking to everybody, but you're not getting to talk to everybody. In closing, I want to share this right here, and I'll get out of here. I want to share a quote from one of our founding fathers and the man who wrote the Declaration of Independence, President Thomas Jefferson, who said, "Whenever the people are well informed, they can be trusted with their own government." This amendment here, although I like what's trying to be done, it is actually going to take all of the discussion in private and keep it from the discussion from being done in front of the people. I highly urge you to vote no. Thank you.
Stop the timer. Up speak against the bill is Joseph Pearson. Mr. Pearson, I would point out that most of the time, considerable amount of time was used. The last speaker, you only have 3 minutes left.
Okay, thank you. My name is Joe Pearson. I've been a JP for 6 years, and I can tell you that in that time, the encumbrance of having to conduct business in full public view is far outweighed by the value of conducting that business in full view of the public. I have seen, on the other hand, the problems of private meetings and JPs coming to quorum court meetings already having solidified their position and no public discourse taking place before a vote. Oftentimes, the deliberation that leads to a vote can be as important or sometimes even more important than the vote itself. I believe it's important for the public to be able to see that process and be able to evaluate it. Furthermore, public comment will become almost irrelevant if this passes, because they'll come ready to vote, and private citizens that come to speak on before the body will in no way sway them, because they've already made their decisions beforehand in private meetings. I would urge you not to do this. Thank you.
Thanks, sir. Speak against the bill is Dr. Joyce. Ma'am, I might point out to you have 2 minutes and 11 seconds left.
Good evening. Thank you, Mr. Chairman.
You're
My
welcome.
name is Dr. Joyce Ajayi. I'm with the Arkansas Center for Research in Economics at UCA. The opinion I'm going to give today is solely mine. I don't want to take too much of your time, but I think that the key question here is not how many members of the public body are meeting. The key question here is this public business? So even if 2 members of a public body are meeting and they discuss public business, then this should be considered a public meeting. If 3 or 4 members meet, but just to discuss their kids' soccer game, that is not public business, and that should not be considered a public meeting. So thus, to the context and the context of the discussion is what matters. So for more explanation on this, I'll refer you. I have a lot of academic references that I can provide if anyone is interested in that. Over the past few months, we've had remarkable occurrences coming up on meetings, public meetings. And all of these occurrences raise concerns about open and accountable government. Lawmakers do have a chance during this legislative session to clarify the features of transparency in public meetings, not further complicate the law. This bill will further complicate that law. And it is my recommendation that this bill should not pass.
Great job.
Thank you, ma'am, for your testimony. To speak against the bill is Carl Watson. Mr. Watson, I point out you only have 39 seconds. Are you still here?
He has to go to a different committee.
Who's next? Joey McCutcheon, you've got 39 seconds.
I can't get my name out in that time.
I want to see you do this.
There was no compromise. The bill was not taken to the task force after it was amended. Yesterday we met in the FOIA task force, and Ms. Bentley chose not to be there. this will allow serial meetings. The question that I have is, there's many other definitions of meeting, which should be included. What is a chance meeting or a social gathering a meeting? Whether a project or a program in a district is a meeting. And that would have been answered if Ms. Bentley would have come to the task force and legitimately had a compromise. Does a body having serial meetings, 4 + 4 + 4?
Mr. Coach, time's
That's
up.
secrecy. Thank you.
Thank you, sir. We appreciate it. Signed up to speak for the bill is Mr. Strain, Samuel Strain. Yeah, or, Justice Strain.
Hello, everybody. My name is Justice Samuel Strain.
I would point out to you have the floor side has 15 minutes and the time starts now. You're recognized to give your testimony.
Okay, thank you. I'm a Justice of the Peace in District 4 in Faulkner County, and the idea that there's not an imbalance of power, as I think, is pretty ridiculous, because the judge can talk to any of the JPs, and he talks to the JPs that he likes, and they come up with whatever ordinances they want, and those of us that aren't in the loop get blindsided by that. Happens every month. I'm sure it happens at other meetings, but of course, if you get along good with the judge and you like to do things his way, then that's fine. You don't need any kind of meeting with anyone else. I think the main thing I think after listening to all these things is just to mention a couple of cases where it actually affects you guys because you have JPs of your own. And to give you a couple of examples that we've been trying to for 10 years, before I was on the court, they've been talking about the need for an animal shelters. We've had children killed by animals. We've got all kinds of animals all over the county. There's a lot of volunteers, organizations. My own daughter was walking her dog and had her dog killed by a stray animal. And the only answer that you get from the sheriff is, I understand their situation as well. Take your gun and shoot the dog if you feel threatened, or shoot the animal, whatever it is. So we spent $400,000 to buy a building to convert to an animal shelter or remodel. And they're saying that it's going to cost $1.6 million to remodel the building. So we're looking at $2 million to get an animal shelter built, a whole new bureaucracy they want to put in place. I'm more concerned about just taking care of the vicious animals myself, but one of the animal shelters in Faulkner County that already had a facility went out of business a couple of weeks ago, and the JP that is in charge of courts and public safety, a new member of the quorum court, found out about this and got a chance to look at it. She was afraid to call the other JPs, just worked through the judge's office, didn't get a lot of cooperation there. The building sold for, it was pretty much ready to go, just slight modifications. It sold for $200,000, which I don't know if you subtract the difference. I think that's 1.8 million. So it's costing you money, us not being able to talk, because she could have called the other JPs. We could have had a special meeting and possibly bought that facility and sold the one that we spent $400,000 on. So it's costing you money. Another thing is they've been talking about a jail for a long time. It's, two of us can't go down and talk to the sheriff about and get a tour of the jail together. And it's a situation where we have the infrastructure committee needs to be there. Somebody from the courts and public safety committee needs to be there, but we can't go together to look at the jail and see what he needs, see what the needs are, because everybody's afraid to do anything together because of FOIA. I think it's unreasonable to not let at least two people from different committees that are going to be involved in making a decision to not be able to go and view the jail. Another situation is we've got somebody requesting to add additional length to their pipeline. It's a city in Faulkner County, or a small town, actually, I should say, that wants to extend their water lines into the county. That would benefit the people in the county. You know, it would be nice if the public safety committee person or the JP that's in that district and somebody from the infrastructure committee could go and view that project and see if they're really telling us the truth about what they need the money for. We've spent almost $18 million of the FOIA, not FOIA money, the ARP money on projects. Nobody's ever gone to inspect any of the projects. We're just taking the word of the people that say, well, we need this money to do whatever. But nobody from the court goes, because nobody from the court really can get together. And I just feel like we need some relief here. It's not unreasonable, in my opinion, for somebody from the infrastructure committee and somebody that, you know, whatever district whoever is in, if we went up there and got a view and got a tour of what they're trying to accomplish, you know, oh, is that a secret meeting? My goodness, you know, we're just trying to get information that we can bring back to the committee meetings and discuss it in public to give some feedback to the committees. And I think that's a reasonable request, and that's why I'm supporting this bill. I'd be okay with 2 or 3 or less, you know, as long as 2 people can get together and go look at something. Somebody from the committee that's involved and somebody from the county or the district that is represented by that particular need. And it's costing you money because we spent a lot of money on projects that have never even been looked at, you know. So thanks, Mary, for what you do.
Thank you for your testimony. Seeing no one else has signed up to speak for the bill, that concludes testimony at this time. Representative Bentley, you recognize, close with your bill.
Colleagues, I know, like me, you're exhausted, and I appreciate you staying to hear this bill. I really do. And I think JP Strain just really said what I want to say, why we need this. We need good and efficient, effective local government, just like you and I get to talk and visit and do good things for our constituents. A lot of times JPs get to that meeting and don't say anything because they haven't had a chance to visit with the person that ran that ordinance. If they had a moment to visit with that ordinance, the JP that ran it, they would be able to come and ask good questions, and we'd have good dialogue and good things going on in our JP meetings, just like we do here. And to say that public input would not influence those JPs like it influences us is just a complete lie. We'd like to hear from constituents, and they would like to hear from their constituents. I want a good job by our constituents who voted for their JPs, just like we've been voted and elected to do a good job on ordinances and in between, on projects. So with that, colleagues, we're exhausted, and I'm finished.
You have a motion.
I have a motion to pass.
Representative Bentley's made a motion to pass. Any discussion on the motion? Seeing none, all in favor say aye.
Aye.
All opposed say no. No. The ayes have it. The bill is passed. Roll call. I see 2 hands.
Representative Meeks. Representative Meeks. Representative Jean. Yes. Representative Jean, yes. Representative Wardlaw. Representative Wardlaw. Representative Wardlaw, yes. Representative Miller. Representative Miller. Representative Womack. Representative Womack, no. Representative Bentley. Yes. Representative Bentley, yes. Representative Gonzalez. Representative Gonzalez, yes. Representative Beck? Yes. Representative Beck, yes. Representative Richmond? Yes. Representative Richmond, yes. Representative Gazaway? Representative Gazaway? Representative Crawford? No. Representative Crawford, no. Representative Scott? Yes. Representative Scott, yes. Representative Clowney? Representative Clowney? Representative Milligan? Representative Milligan, yes. Representative Carr?
Yes.
Representative Carr, yes. Representative Underwood?
Yes.
Representative Underwood, yes. Representative Berry?
Yes.
Representative Berry, yes. Representative Moore?
Yes.
Representative Moore, yes. Representative McElroy?
No.
Representative McElroy, no.
Congratulations, Representative Bentley, your bill is passed.